Todos, meu nome é Leonardo Nemer Caldeira Brant. Bom dia a todos, meu nome é Leonardo Nemer Caldeira Brant. Eu presido o Centro de Direito Internacional com sede em Belo Horizonte. É com muita alegria que eu saúdo a todos os presentes, saúdo igualmente os professores internacionais e nacionais que irão estar conosco durante essas 2 semanas, durante o 16º Curso de Direito Internacional. Eu gostaria de dizer que, em primeiro lugar, esse curso foi todo desenhado num novo modelo online. Nós já estamos aí no 16º curso desse gênero. Ele foi totalmente adaptado às novas circunstâncias, o que, de certa forma, permitiu também uma extensão do número de participantes, de professores internacionais e nacionais participantes. Temos este ano 19 grandes nomes do direito internacional que estarão presentes conosco durante essas 2 semanas. Num primeiro momento, portanto, eu gostaria de agradecer a todos os professores que colaboraram conosco, que estarão conosco nesse período, com palestras muito interessantes sobre temas dos mais variados do direito internacional. A todos eles, o meu muito obrigado. Em segundo lugar, saúdo e agradeço também aos alunos, aos estudantes que estão participando neste período de julho, conosco durante essas 2 semanas. O nosso também muito obrigado. Esse é um curso que envolve uma grande equipe do Centro de Direito Internacional, a qual eu tenho imenso orgulho de colaborar e de presidir. Ele é um curso que pretende trazer para o Brasil e para a nossa América Latina o mesmo modelo de cursos que, de forma quase centenária, já é uma tradição nos países europeus e nas principais universidades do mundo. Portanto, para nós, uma grande satisfação que tenhamos ele já há mais de uma década no Brasil. O curso de inverno de Direito Internacional, com toda a sua abrangência e extensão, não seria possível de ser realizado igualmente se não fosse a relevante parceria e a confiança e o apoio da Fundação Konrad Adenauer no Brasil. A ela estendo um caloroso agradecimento e tenho a certeza de que estamos contribuindo juntos para os valores do direito internacional, para os valores dos direitos humanos, para os valores do Estado Democrático de Direito, para os valores da democracia e, com certeza, para a compreensão e construção de um mundo, de um universo internacional mais justo e mais equilibrado. Portanto, agradeço de forma calorosa ao apoio da Fundação Konrad Adenauer no Brasil. Gostaria, portanto, de dar início ao 16º Curso de Inverno de Direito Internacional, esperando que todos tenhamos 2 semanas de muitas atividades e aprendizado. Um forte abraço a todos.
Good morning, ladies and gentlemen. It's an honor to be here with you in the 16th winter course of international law. And I'd like to thank Professor Leonardo Nemer Brandt for the opportunity and congratulate Cedin for hosting this course. Today, we will have the honor to receiving Professor Pierre Dargin, whose lecture will be on international obligations today and tomorrow. Professor Pierre Dargin is a professor at the University of Louvain and a guest professor at the University of Leiden, member of the Institute of International Law. He's the author of numerous articles, an award-winning book, a massive open online course on edx.org, and courses at the Hague Academy of International Law and the United Nations Audiovisual Library of international law. He's also a member of the boards of the European, French, and Belgian Societies of International Law. He appeared as consul before International Court of Justice and later served at the ICJ as first secretary. He's a member at the Brussels Bar, special counsel at Foley H. Hoag. It's an American firm, law firm, and argues international law cases before international tribunals and domestic courts. Thank you, Professor Dajan. It's a joy and a pleasure to hand you the word. Thank you.
Thank you very much for your very kind introduction, dear colleague, Professor Vedovato, and thank you also to Professor Brandt and all the team that has been putting up this session of courses. It's only too bad that we can't meet physically and be all present together, but I'm very pleased, ladies and gentlemen, to address you today and tomorrow. And I hope that you will have questions on the course. So today my purpose is to introduce the topic. And as Professor Vedovato just recalled, this course is about international obligations. And of course, I have to give you some words of introduction as to the scope and the purpose of the course. And I will continue tomorrow with the course, but in the meantime, after 1 hour of teaching today, we will have a session of questions during which you will be able to raise all sorts of questions or comments that you may have on what I would have said beforehand, or any other problem you would like to raise in relation to international obligations. Now, let me introduce the purpose of this course. In a way, what I aim to do with this course, and maybe I should say right immediately that international obligations was the topic of the course, the specialized course I taught a few years ago at the Hague Academy of International Law, and my course was taught in French, and it's in. I've been a little bit delayed in publishing the course, unfortunately, but it's in the pipeline. It's in the process of being published. Now, the purpose of the course really is, it's a course. It's there to teach and to help students, learners of international law to, as it were, read the music of international law. I'm not going to deal with a specific regime of international law. I'm not going to teach you about human rights or the law of the sea or international environment or armed conflicts. I'm going to teach you about fundamental structures of international obligations. And my claim in that course is that any field of international law, any obligation in all fields of international law can be, if you wish, if you want, can be reduced or can be summarized in some fundamental aspects that you will find back in every single international obligation. It's a big claim. It's a claim that despite the diversity of obligations, and international obligations are extremely numerous, okay? Despite their diversity, there are some fundamental archetypical types of obligations that can be laid out, set out, and having those in mind, those fundamental character of international obligations in mind, keeping those in mind will help adjudicators, creators of international obligations, that is, negotiators of treaties, will help them to better understand the commitments that they are either taking when they negotiate a treaty or the commitments that they interpret when they are adjudicators. So my claim is that through a better understanding of the fundamental structures of international obligations, the capacity of treaty-making bodies or judges is increased. Okay, despite the diversity of international obligations, they can always be summarized into some fundamental structural aspects, and that is what I call reading the music of international law. It's really a technical aspect of the law. Okay, and I will try to convey to you, okay, this enhanced mental structure that you can have for the analysis and understanding of international obligations. Now, this course takes international law and international law obligations seriously. Okay, I am speaking from the point of view of the existence of international law, and I'm not putting that existence into question. Okay, of course, it's always a question. But I assume international law exists, I assume international norms exist, and those norms contain rules, and those rules contain obligations. And let me start from there. International obligations are expressed by rules that are contained in norms of international law. Let's take an example. Article 27, paragraph 3 of the Vienna Convention on Diplomatic Relations. That provision states that, I quote, "the diplomatic bag shall not be opened or detained," end of quote. Well, the obligation, you understand immediately that the obligation is not to open nor detain the diplomatic bag. That is quite straightforward. Such obligation is expressed by a rule that is contained in a treaty, and that treaty is made of words. And the same obligation exists under an identical rule of international law under customary international law. In this example, the obligation not to open, not to detain the diplomatic bag is almost impossible to distinguish from the rule that expresses the obligation. While different types of international norms convey the same obligation through identical rules. So you may have a customary rule, a treaty rule, they are the same and they convey the same obligation. And let's take by contrast also another Article 27, paragraph 3, but now of the Charter of the United Nations. That provision says that decisions of the Security Council on all matters, that is non-procedural matters, decisions of the Security Council on all other matters shall be made by an affirmative vote of 9 members, including the concurring votes of the permanent members. You know that rule for the adoption of resolutions by the United Nations Security Council. Well, such a rule is of a purely conventional nature. It is contained in the Charter of the UN. It is not of a customary international law character. It conditions the validity of the adoption of Security Council resolutions. It appears to be a rule only, a procedural rule only. But actually, you can read that rule as containing an obligation, and the obligation is addressed to the UN itself. And it is an obligation not to consider as duly adopted a resolution that would not have met the number of votes required, 9 members, including the concurring votes of the permanent members. Okay. the rule contains an obligation. It's an obligation to consider adopted a resolution that confirms with the rule, and it's also an obligation not to consider adopted or to consider not adopted a resolution that would not have, a draft resolution that would not have been adopted under that procedural rule. And of course, we can all have different understanding, different theoretical understandings of rules and norms, okay? And you have millions of books in libraries that talk about what is a rule, what is a norm, is there a difference between a rule or a norm? But let us accept, for the purpose of this course, let us accept as operational the distinctions I made above, okay? And let us work on the assumption that rules convey, rules are conveyed by norms, and they exist because they contain obligations, okay? So you have the norm that contains a rule, and the rule contains an obligation, okay? The norm is really the question of the sources of international law. What is the source? Is it a customary rule of is the norm of a customary nature, or is it a treaty a norm, or is it unilateral act of an international organization, or a unilateral act of a state? That is the question for the existence of norms. And the theory of the sources of international law is helpful to determine how norms come into existence. Well, those norms, once they come into existence, they contain rules, okay? And those rules contain obligations. And the rules will be interpreted to make sure and to discern and to identify the content and scope of the obligations, okay? So the issue of interpretation relates to the rules, and the product of that interpretation of a rule leads to the identification of an obligation. And what I'm interested in is, try to reveal the structure of the obligations, the end product, as it were, of interpretation of rules contained in norms that exist under a theory of sources, okay? And an obligation is a legal command. That is what is important. An obligation is a legal command in need of performance. The purpose of an obligation is to direct behavior, okay? It requires a certain behavior, and therefore an obligation always limits the freedom of the subject that is bound to respect the obligation, okay? That's the very purpose of an obligation. It is to limit the behavior. It is to direct the behavior in the real world of subjects that are bound by the obligation. And as you know, much international legal scholarship has been devoted to the issues of norms. That is the question of the sources of international law. A theory of sources allows to distinguish between words that pertain to the realm of law and other words that do not pertain to the realm of law. And I think, I'm sorry to be a little bit theoretical, but it is very important to keep in mind that law, whether international law or domestic law, law is only and always made of words, okay? Rules, obligations are expressed in words, and the same words are used for very different purposes in life. You can use words to write a poem, you can use words to, tell your friends how a good day you had, and you can use words to write down rules that are going to be binding. So it is important in any legal system to be able to distinguish between the words that command under the law and those that do not. And that is why we have theories of sources in every legal system, secondary norms, norms about the norms, okay, that allow you to distinguish within the flow of words which are the words of the law, the commanding words of the law. And a theory of sources is about the existence of words as law, the validity of a set of words as law. And that is important, of course, to be able to discern, because as Kelsen used to say, law is about how one ought to behave, okay? How one ought to behave. The commanding structure of obligation is fundamental. And so you must know what are your obligations. And that is made clear through a theory of sources that will allow you to identify norms. Those norms contain rules, and those rules will convey obligations. Let me submit to you that any theory of sources, including, of course, in international law, a theory of sources of the law is deeply, deeply political. It is deeply political because precisely it is there to discern between law and not law. And why is it political? Because law always and at the same time, law justifies and limits power. It is because you have a rule of law that you will be able to contest the exercise of power. And it is because there is a rule of law that not only you will be able to contest the exercise of power by somebody, but it is also because there's a rule of law that this person will be able to justify the exercise of power. Okay, that is true in domestic law, in constitutional law, in private law, but that is true also in international law. The law will always and at the same time be an instrument to justify the exercise of power and to limit such exercise at the same time. Okay, you submit yourself to the law by claiming authority under the law. Okay, if you're a tenant and if you have a contract with your landlord for renting the house where you live, you have obligations on both sides, and those obligations under the law will justify a certain exercise of power by yourself, a limitation of your power vis-a-vis your landlord, and vice versa. So it's important to keep that in mind. And theories of sources of international law, I'm not going to go into details about the sources of international law, and I presume you have been taught about the sources of international law, but it's important to keep that in mind, that sources are always debated in international law, because behind the question of sources lays a very important political question, okay? And the political question relates to the exercise of power, to the limitation and the justification of the exercise of power under the law. And the theory of sources does actually two things. A theory of sources indicates who has the authority to make law and how law is made. Okay. When you look at the theory of sources in international law, customary international law, treaties, etc., they always boil down to those two issues. Who has the authority to make law, and how is that authority exercised in order to produce something that is called law, something that is a norm. That norm contains rules. And the reason for those rules is to have obligations that will limit and that will constrain the behavior of subjects. And again, I want to refer to Hans Kelsen, who used to say that international law can be defined solely by the way in which its norms are created. Okay, that's really the idea, that to identify international law, what makes international law so specific? Well, if you want to understand international law, you have to understand how international law norms are created. Okay, a theory of sources. And a theory of sources allocates authority in the system. Who has the authority to make law? That's a very, very important question for any legal system. Who has the authority to make law and how law is made? That's really a fundamental question. And international law scholarship has been obsessed for decades and decades and decades. International law scholarship has been obsessed with the question of the sources of international law. Article 38 of the ICJ statute. Look at the works of the International Law Commission. So many of the draft articles of the International Law Commissions are about sources. Okay, you can look at the law of treaties in the past. You can look today on the work of the ILC on jus cogens, for instance, or on reservations. All that relates to the issue of sources. Is there law, and how can it be that law exists? So that's important, I think, to keep in mind. And of course, much has been said about the bindingness of international law, the reasons for having norms, and how norms are created. Less attention, however, has been paid to the modalities of the product of the law, the modalities of the obligations. And that is my topic, if you wish. I would like to see, and I will propose a theory about a typology of international obligations. Okay, the question is there law or no law has been very much studied. Okay, and it's a very important question. Is there law? Is such a rule of international law or not? Let's go beyond that question. Let's go a step further, and let's try to understand that the reason why we have rules is because those rules contain obligations. And the reason why we have obligations is because we want a certain behavior. Okay. We want to change reality. And my purpose is to try to discern how obligations under international law are structured. Okay. And this is, of course, a very pretentious thing. Is it really possible? Despite the diversity of sources, despite the diversity of norms, despite the diversity of rules, is it really possible to discern and to try to reduce that diversity into some fundamental structures that are pertinent to obligations? And for instance, you have someone like James Crawford, who is now judge at the ICJ. James Crawford has been very skeptical about the possibility of, establishing a kind of general theory of obligations. He wrote, "We are far from a grand unified theory of international obligations." Okay, so it may appear a little bit an illusion to try to discern structural elements that are common to all obligations. But that's what I'm pretending to do. That's what I would like to convey to you, that it is possible to reduce international obligations to some fundamental elements. So I'm not going to, I mean, what I'm going to say, I think you know it already. What I'm going to do is simply putting the pieces together. I'm going to take some elements from here and there, and I'm putting them together to have a better and clearer picture of international obligations. And that is the purpose of this course. And so my claim, and let me go after this long introduction to what I'm claiming. I'm claiming that legal obligations are always relational. Legal obligations are relational in two fundamental ways. On the one hand, obligations link subjects with each other. Sometimes they link subjects with each other about things of the world, okay? You can have obligations about the sea. You can have obligations about rivers. You can have obligations about the moon, okay? Those are things of the world. It's not necessarily obligations. Those obligations about things of the world, nevertheless, establish relations between subjects, okay? And my first claim is that an obligation always has this social relational dimension. It always links subjects, okay? And in order to understand obligations, we have to turn to that relational aspect of obligation first. On the other hand, an obligation does not only link one subject vis-à-vis other subjects, but an obligation has also a binding effect on the subject, on the debtor itself, okay? The obligation requires a certain behavior from the subject owing the performance of the obligation. So if you want, there are always in every obligation, and I think this is true in international law or in domestic law, every obligation has a twofold relational aspect. When you have an obligation, you have a relationship with others, and you also have a relationship with yourself, because the obligation compels you to do something, to behave in a certain way. And while you do that, you owe that behavior not only vis-à-vis yourself intrinsically, but you also owe it vis-à-vis certain subjects, okay? And so you have this twofold relational element of an obligation. An obligation has an external, extrinsic aspect, and an obligation also has an intrinsic, internal aspect, okay? And I'm going to try to show you that there are certain extrinsic modalities of obligations, some fundamental extrinsic modalities, and some fundamental intrinsic modalities of obligations. And my claim is that if you want to understand what an international obligation is actually about, you have to combine those extrinsic and intrinsic modalities, okay? And every international obligation will combine one extrinsic modality with two, and I go a little bit further in my claim, with two intrinsic modalities, okay? I'm sorry, this is very abstract, and maybe it is time now to to share with you my screen to show you more concretely what I have in mind. My claim is that there are two extrinsic modalities of obligations, and those extrinsic modalities is an obligation is either bilateral or collective. Those are the two possibilities for extrinsic modalities of obligations. Either an obligation is bilateral or an obligation is collective. Okay. Bilateral or collective is a matter of extrinsic modality. It is the relationship with the others outside. You owe the obligation to whom? That's the question. And you will characterize the obligation as being bilateral or as being collective. And I will say a few words today about what is a bilateral obligation, what is a collective obligation, and what are the regimes that flow from that distinction in the law of treaties and under international responsibility. Okay? So one pair of extrinsic modalities, bilateral or collective. On the side of the intrinsic modalities of obligations, my claim is that there are two pairs, and the alternative, an obligation is either negative or positive, and for intrinsic modalities, you have a second pair of alternative possibilities. The obligation is either an obligation of result or an obligation of conduct. Okay. Negative, positive, result, conduct, those are pairs of intrinsic modalities of obligations. Okay. And in order to understand an obligation, you will always end up combining those dimensions, those characteristics. Okay. The obligation, and because you have one pair of extrinsic modality and two pairs of intrinsic modality, theoretically, you could have all those combinations, which are 8 combinations. However, it is logically impossible to combine a negative obligation with an obligation of conduct. So you have to strike out an obligation that combines negativity with conduct. That's impossible, and I will explain why. And that's why you have bilateral. It's not possible, and it's maybe it's a good point. I would like to be challenged on this. If you can find in your mind now, today or tomorrow, an obligation that could be said either bilateral or collective, but negative and of conduct, I would be very interested. Once, of course, I will say what is a negative or positive obligation, and I will say what is an obligation of conduct as opposed to an obligation of result. But I think it is impossible to have a negative obligation of conduct. If that's the case, then we have to strike out an obligation that would be either bilateral negative and of conduct, or an obligation that would be collective negative and of conduct. Those possibilities, I think, in the real world do not exist. So we end up with 6 fundamental types of obligations. The obligation can be an obligation bilateral, negative, and of result. And for instance, I gave the example of the diplomatic bag that cannot be opened nor detained. That is precisely an example of a bilateral obligation, a negative obligation, and an obligation of result. Okay. You can have a bilateral obligation, which is a positive obligation. Instead of commanding not to do something, it commands to do something. Okay. And it's an obligation of result, not simply an obligation of conduct. And I'll go into details on that. And I will deal with obligations of result and obligations of conduct tomorrow. Okay. We can also have collective obligations that are negative and of result. And for instance, I would claim that the prohibition on the use of force, Article 2, paragraph 4 of the United Nations Charter, which also exists under customary international law, I would claim that such a prohibition can be characterized as a collective obligation that is intrinsically negative. It's a duty not to use force, and it's an obligation of result. Okay, it's not simply making your best efforts to avoid using force. It is a command that prohibits the use of force, full stop. Okay. You also have collective obligations that are positive obligations of result. The state must do something, and by doing something, it must achieve a certain result. And those are obligations that are owed collectively. And you have obligations that are collective, positive, and of conduct. For instance, if we take the obligation to prevent genocide, it's a collective obligation, and I will explain what it means today. It's also a positive obligation. The state has to do something, to act. But, however, it's an obligation of conduct. It's not, the state must do its best efforts, and the obligation is violated, is breached by the state if the state does not do its best efforts. But the state is not obliged to make sure that genocide does not occur. The breach of the obligation is the breach of a best effort obligation. Okay, so that's my claim, and it's very theoretical so far. I'm sorry about that, but that is where I would like to guide you and to study with you. And of course, it is by interpreting the rule of international law that is contained in a norm that we can discern if the obligation is bilateral or collective, if the obligation is positive or negative, if the obligation is of result or of conduct. Okay. And my claim is that by identifying those differences, we identify problems, regimes, okay, that follow from such qualification, okay, and that those understandings are not necessarily made by courts and tribunals, not made explicitly, not always made explicitly. But however, those distinctions are always looming large. They are always there in the mind, and they can be made explicit. And if they are made explicit, my claim is that we would have more clarity and more consistency in the application and the interpretation of international law. Okay. So I don't know if there are questions so far. Maybe we'll take the questions later on. I'm of course ready to pose here if there are questions. But I would like today, this morning, to cover the extrinsic modalities of obligation. That is the distinction between bilateral and collective obligations. And the distinction is not simply about the relationship between the bearer of the obligation and the corresponding right holder. The distinction is about the legal interest for requesting compliance with the obligation. That is what is behind the distinction between bilateral and collective obligation. And as you know, we have been moving historically in international law. We have been moving from an international legal order of where the emergence of collective obligations is very much the novelty of the 20th century. We have been moving, as it were, from an international legal order where obligations were basically bilateral, owed from one state to another state, to a world where collective interests have been protected under the law, resulting in collective obligations. And that's a fundamental trend of the 20th century, of the second part of the 20th century. It is the emergence in international law of the protection of collective interests. And that political development in international law, resulting in new rules, new regimes, new obligations, that development has been translated into the structure of international obligations. Okay? So much so that what being bound by a rule of law, what it means to be bound by international law has been considerably transformed over the last 5 decades. Now, let me quickly go to bilateral obligations. A bilateral obligation is an obligation that establishes a relationship between two subjects and two subjects only. The debtor owes the performance of the obligation and the beneficiary of such performance, the beneficiary of the performance is the bearer of a subjective and personal right to the performance of the obligation. So a bilateral obligation really expresses what it means, that you have the debtor, the bearer of the obligation, the subject that owes the obligation to another subject. The reality of international law historically has been very much structured around that bilateral characteristic of obligations. Okay, hundreds and hundreds of obligations are of that type, and I gave you as an obligation the obligation not to open the diplomatic bag. Irrespective of the multilateral character of the source that contains the rule, the obligation is bilateral. Okay, you have a multilateral treaty that contains a bilateral obligation. Take, for instance, also in the law of the sea, the right of innocent passage. The right of innocent passage is owed by the coastal state individually to all other nations, but on an individual basis, okay, on a bilateral basis. And that bilateral nature of obligation may exist irrespective of the source, whether it is customary international law, whether it is a treaty, whether it is a unilateral act of state or a unilateral act of an international obligation, of an international organization, sorry. If you have a bilateral treaty, of course, in a bilateral treaty, the obligations can only be bilateral. They cannot be collective. And in a bilateral treaty, the reciprocity is total. And under the law of treaties, you know Article 60 of the Vienna Convention on the Law of Treaty, which is the inadimplenti non est adiplentum mechanism. If one party violates the treaty, the other party may suspend the obligation under the treaty. So in case of a material breach of the treaty, the other party may in a bilateral treaty, eventually suspend or even terminate the treaty. And that's Article 60, paragraph 1 of the Vienna Convention. The material breach of a bilateral obligation in a bilateral treaty can be suspended or terminated. Now, if the obligation is bilateral but contained in a multilateral treaty, then it is the only possibility is the suspension of the treaty, not the termination of the treaty. And it is only the party that is specially affected by the breach that can suspend its own obligations under the multilateral treaty. And the suspension will only occur vis-à-vis the defaulting party, okay? That's why it is a bilateral obligation, irrespective of the multilateral character of the norm, of the source, the treaty. The obligation will continue to be owed and performed on a bilateral basis. And the suspension of the treaty in case of material breach will be limited to the relationship between the debtor of the obligation and the party to which the obligation is owed in a specific case. Okay. Under the Vienna Convention on the Law of Treaties, and I'm not going to go too much into details, the termination of terminating a multilateral treaty that contains bilateral obligation is possible, but only with the unanimous agreement of all other contracting parties, which is very unlikely to happen. And this is Article 60, paragraph 2a of the Vienna Convention. This is very unlikely to happen, which in practice means that when you have a bilateral obligation breached, materially breached, the sanction of that breach under the law of treaty will actually only concern the specially affected party, and the rest, even if there is theoretically a possibility for the other contracting parties to react, they will not react because their reaction must be unanimous. Under the law of international responsibility, this distinction or the characteristic of an obligation as a bilateral obligation is also of important consequence. As you know, the state to which the obligation is owed individually may invoke the responsibility of the defaulting state, and this irrespective whether the breach is material or not. And the injured state, those are the words of the ILC, the injured state is entitled to the benefit of the secondary obligations, cessation, reparation, assurances and guarantees of non-repetition. And the injured state is also the state entitled to take countermeasures in order for those secondary obligations to be duly performed. So the bilateral obligation, characterizing an obligation as bilateral, has consequences under the law of treaties and also under the rules of state responsibility. In contrast, I'm looking at my watch, in contrast, collective obligations are owed in any given case. Okay, they are not collective obligations. This is the specificity of a collective obligation. A collective obligation protects a collective interest, a common interest, common values, and the performance of that obligation is of interest to all other states in any given case. Not only when that state is concerned, okay, individually. The obligation is collective not because the performance of the obligation is owed bioplurality of subjects ut singuli, but because it protects common interests and values. And compliance with the obligation is not to the benefit of any state. It is to the benefit of the collectivity of every single state. So the specificity of collective obligation is to multiply the subjects that have a legal interest in the performance of the obligation. Okay, those obligations are of concern to a collectivity. Even when the performance, even if the performance is not to the individual benefit of sorry, I'm confused. Is not in the even if the performance is in the collective interest, even if the performance of the obligation is owed in a specific case to a certain subject, that due performance is of the interest of a collectivity. Now, a collective obligation will be labeled, will be called erga omnes obligation when it exists under a rule of customary international law, and it will be called an erga omnes partes obligation when it exists under a multilateral treaty. The distinction between erga omnes and erga omnes partes obligations has been the subject of many doctrinal debates. I think today those debates have been solved by the case law of the International Court of Justice in, for instance, the Belgian-Senegal case, or in the recent Gambia-Myanmar case. I was serving with the court at the time of the Belgian-Senegal case, and now I'm counsel to the Gambia in the Gambia the genocide case against Myanmar concerning the Rohingyas. The court made clear that distinction between erga omnes and erga omnes partes obligation. In both cases, whether the obligation is erga omnes or erga omnes partes, any other state or any other state party, if it is a erga omnes partes obligation under a multilateral treaty, any other state may request the performance of the obligation by all other states bound by the obligation, and may also request the cessation of the breach. Okay, that's very important. Requesting the cessation of the breach, and any state has an interest in requesting cessation of the breach. The ILC also says that any state may request also assurances and guarantees of non-repetition, and any state may also request, in the interest of the injured state or the injured individuals, may request the performance of the obligation to make good the damage, the obligation of reparation. Now, that last element is probably a development of international law. We don't have a case making clear that performance of the obligation of reparation may be claimed to the benefit of any other state or individuals. But the Gambia case will probably make, if it goes to the merits, will have to address that issue. We have debates in international law about whether a non-injured state may take countermeasures to force or to lead the responsible state to cessation, assurances of non-repetition, and reparation. But I will leave those debates for now. It is not clear whether all states, despite having a legal interest to raise and to invoke the responsibility, whether all states may use countermeasures to force the responsible state to duly perform its obligations. Now, I have more things to say, but I see that time is passing by. I would like to draw another distinction within collective obligations. I said you have either erga omnes or erga omnes partes obligations. Within erga omnes partes obligations, you have the distinction between interdependent or integral obligations. Now, that's another distinction I would like to make. Those are collective obligations under multilateral treaties. For that purpose, they can be qualified as erga omnes partes obligations, but they are very different indeed, very different. The distinction between interdependent and integral obligations is a distinction made by Fitzmaurice when he was Special Rapporteur on the Law of Treaties. And it's a distinction that was made in 1957 in one of his reports. It's not a distinction that has been really reflected in the Vienna Convention as such, although we can see some traces of that distinction, and also in the ILC draft on state responsibility. But I think the distinction is intellectually correct and actually very useful. What is an obligation? What is a collective obligation that is interdependent? A collective obligation that is interdependent is an obligation that exists when the fundamental breach of such obligation by one party will justify the corresponding non-performance by the other parties. Not simply the non-performance in relation to the defaulting party, but non-performance vis-à-vis all the state parties. For instance, an interdependent collective obligation exists in disarmament treaties. If you have a disarmament treaty, and if one party does not duly perform its obligation, then all other parties in the treaty may themselves suspend their own obligations, not only vis-à-vis the state that has not performed its own obligation, but vis-à-vis all other states. Okay, if you have a multilateral treaty of disarmament, it makes no sense to continue to perform your obligation to disarm if one of the parties does not perform its own obligation. And we are talking about a multilateral treaty, of course. The material breach of an interdependent obligation allows each party to suspend the treaty in whole or in part. And that is made clear by Article 60, paragraph 2C of the Vienna Convention on the Law of Treaties. And in the law of state responsibility, the breach of an interdependent obligation will lead to the injury to all states belonging to the group of states as being injured states. So those states will be able to take countermeasures, okay? Even if they will be, under the law, presumed injured. They will not necessarily suffer any material injury, but they will be considered as injured and therefore having the possibility to take countermeasures. And that will distinguish their specific interests. Okay, it's an erga omnes partes obligation that is characterized as interdependent, and that will lead to a specific capacity to take countermeasures. Even if they are not specially affected, they are presumed injured because the obligation is interdependent. That's one type of collective obligation. type of collective obligation. The other is integral obligation. And the integral obligation is the opposite. The integral obligation exists when the force of the obligation is self-existent. It is absolute and inherent for each party. And it is not dependent on the corresponding performance by any others. For instance, the obligations under the 1949 Geneva Conventions applicable during armed conflicts. Those obligations are integral. You must, for instance, respect the status of prisoners of war, even if the other side does not. Okay. So the performance of your obligation does not depend on the performance of the same obligation by another party. And this is, for instance, reflected in Article 60, paragraph 5 of the Vienna Convention. Obligations that are integral cannot be suspended by way of inadimplenti, non est adiplentum. Okay. Likewise, under the law of state responsibility, integral obligations are not affected by countermeasures. You may not, by way of countermeasure, suspending integral obligations. Those are the distinction that I wanted to convey to you. I see that it's nearly 10 over, so I will probably stop here. Maybe you will have questions on the relationship between erga omnes and jus cogens. Maybe you will have questions about the case law of the court, and it might be very useful to illustrate what I've been saying by referring to cases. But those distinctions, I think, are well known to you. What I want to convey to you is that from those distinctions, characterizing an obligation as bilateral or collective has implications in terms of regime that flow from such distinction. But I will stop here, and I will be happy to take your questions if you have any, knowing that tomorrow I will address the intrinsic modalities of international obligations, that is the distinction between positive and negative obligations, and also the distinction between obligations of conduct and obligations of result. And I suggest to leave those distinctions for tomorrow and eventually take today your questions concerning bilateral and collective obligations and all sorts of issues that you may have in that regard. So I'll stop from here. Thank you for your attention. Sorry, it has been very intense.
Thank you, Professor. It was wonderful to hear you. We have a lot of questions here. I think we have 4 of them that are connected, and I'll send you and read it to make sure everybody heard it.
Sure.
So the first one is from Sarah. She says, Professor, could you please explain the difference between norms and rules that you assume in the beginning of your lecture? Talia asked about the obligation to prevent genocide, for example, cannot be interpreted as an obligation of result in the point of view that deprivation is the result. Moises asks, could the typologies coexist outside the realm of human rights? Conduct/result obligations, where doctrine has understood that they are simultaneously both. In Marina, Prof, what is your opinion about the ICJ judgment in the Serbian on the prevention and punishment of the crime of genocide case? Do you agree that the acts of the Bosnian Serbs militias could not be attributed to Serbia? Didn't Serbia fail to take all measures within its powers to prevent genocide and therefore failed with its obligation? Professor, I think that's the first round. We have more than if you have time.
Yes, thank you very much for your questions. Some of those questions already touch on obligations of conduct and result, but I'm very happy to take them on board today. Let me start with the first one on the distinction between norms and rules. And I fully agree that this distinction is not easy or not natural to make. I made that distinction to help us understand that the obligation is at the very end of the line, if you want. The issue of the norm, for me, the norm is the instrument. Okay, the norm is the vehicle, if you want. Okay, through which certain rules are expressed. And when I say norm, I immediately refer to the sources of international law. Okay, you have procedures to produce law. And as I said, the theory of the sources, look at Article 38 of the International Court of Justice, of the Statute of the International Court of Justice. When treaties are listed among the sources of international law, well, the treaty is an instrument, and in my vocabulary, the treaty will be the norm. Okay, the normative instrument, if you want, the normative instrument. That's my idea of a norm. Normative instrument. Okay, maybe this comes from the French, la norme. Okay. But we can say in English, the normative instrument, the instrument that carries, okay, that contains rules. For instance, you have a treaty with Article 7, and Article 7 contains a rule, okay? Or let me take Article 2 of the European Convention on Human Rights, which protects the right to life. That's a rule, okay, contained in a norm, the norm being the European Convention. Now, the rule that you can read, the protection of the right to life, that rule will contain several obligations, negative obligations and positive obligations, including positive obligations of procedure. And with that, I touch a little bit on the third question. Can this typology exist outside human rights? Yes, this typology exists outside human rights, but that typology very much applies to human rights. Okay, and of course, the tricky part of human rights is that both in the Americas and in Europe, either the Inter-American Court or the European Court have developed or have deduced from negative obligations, they have deduced positive obligations, or they have deduced from rules that are written in a negative form. For instance, Article 3 of the European Convention on Human Rights, sorry to refer to the European Convention, I know it better than the Inter-American Convention, but there are very similar provisions. The prohibition of torture, for instance. The prohibition of torture is the rule. I mean, the rule is written in a negative way. Okay, it is the prohibition of torture. It is a legal command not to torture, and it contains a negative obligation. The state is obliged not to torture, but the courts have also made clear that such obligation, such negative obligation implies positive duties for the state. Okay, and I will come back to that tomorrow. Okay, including the trilogy between that is very specific of human rights obligations to protect, etc., etc. But I think that it is important to distinguish the norm from the rule and the rule from the obligation, because it allows us to see that embedded into certain rules various obligations will exist, okay? And those obligations are not necessarily explicit under the rule. They are sometimes the result of an interpretative process by a court of law that will deduce from a rule a positive obligation, okay? And that's for the first question, the distinction between norms and rules. But please keep in mind that for the purpose of this course, I just equate norms with normative instrument, okay? The normative instrument contains rules that are set out in provisions, and those rules, once interpreted, contain obligations. Okay, but I think so. For instance, you can be in breach of Article 3 of the European Convention on Human Rights because you let your territory used by another state for the purpose of torturing certain person. You yourself, I mean, for instance, Poland is not responsible for having committed torture itself, but for letting the United States using the territory of Poland. And that is a breach of Article 3 because it's a breach of the positive obligation contained in Article 3. Okay. But that's why I think it's important to distinguish norms, rules, and obligations. Now, let me take and I think with that I also answered the third question about whether the typology is valid outside human rights. I think it is valid outside human rights. And for instance, of course, now I turn to the Genocide Convention and the questions relating to the prevention of genocide. And the Serbia, the Bosnia versus Serbia case. Now, I said, by repeating what the ICJ has said, I said that the obligation to prevent genocide was an obligation of conduct, not an obligation of result. This is exactly what the ICJ has said. The ICJ has characterized the obligation to prevent as an obligation requiring the state to do all it can to prevent genocide. But a state that does not, you may not eventually succeed in preventing genocide from happening, but you may nevertheless have been in compliance with your obligation to prevent. And that's why it's an obligation of conduct and not an obligation of result. Okay. Now, in the case, the court found that Serbia could have done better, that Serbia did not do everything it could and should have done. And that's why the court found Serbia responsible for the breach of the obligation to prevent genocide. And the obligation to prevent genocide, the breach of such obligation, requires to demonstrate that the state did not behave with due diligence. I'm going to come to that tomorrow. There's a threshold of due diligence that is applicable to obligations of conduct. And the obligation to prevent genocide can only be breached, said the court, if genocide occurred. Okay, if genocide does not occur or did not occur, then there can be no breach of the obligation to prevent genocide. This being said, and the court also made that clear in the judgment in 2007, this being said, of course, you cannot wait for genocide to happen and then start trying to prevent genocide. No, no, of course not. Your obligation to prevent is triggered much sooner, as soon as you should have known. Okay, either you knew that genocide was likely to happen, or you should have known that genocide was likely to happen. And from that moment, you must do everything in your power to try to prevent genocide from occurring. And that's what the court said in the 2007. I think it is on the structure of the obligation to prevent genocide, the judgment is sound. And the court said that Serbia was in breach of the obligation. Serbia could have done better. Now, two questions arose. Okay, the first one is to know, and that obligation to prevent is clearly attributable to Serbia. It is the Serbian state that did not do, okay, what it ought to do. And I will speak tomorrow about attribution of obligations, of attributions of violations of obligation, of positive obligations of conduct. Sorry, I will speak about that tomorrow. Serbia did not do everything it could have done. Serbia is therefore responsible for a breach of the obligation to prevent genocide, as genocide occurred. The court said in terms of causality, and this is also something that I'm going to touch upon tomorrow, the court said that this breach by Serbia of its obligation to prevent was, however, not in causal relationship with the genocide. Because the test, the causality test applicable, said the court, was that the court was not convinced that if Serbia had duly performed its obligation to prevent, the genocide would not have occurred. So I'm going to come back on that issue of causality tomorrow. It's very tricky because, and that is why I think the distinction between positive and negative obligations is important. But the causality test applied by the court was criticized by some. But it's a fairly logical causality test, I think. Now, the other question relating, sorry, I have to sip a bit of water. The other question put to me in relation to that case was whether I agree with the finding of the court that the genocide was not attributable to Serbia. That's a different question, of course, than the issue of attribution of the violation of the obligation to prevent. Indeed, the court, as you may recall, considered that the Bosnian Serbs, who were physically, materially responsible for the genocide at Srebrenica, the Bosnia Serb militia who killed the 88,000 men in Srebrenica, this conduct was not attributable under the rules of state responsibility to Serbia, because they were not organs of the Serbian state, and also because there was no proof that they acted under the instructions, the directions, or the effective control of Serbia. Now that's the rule of attribution. And clearly, as you know, the court wanted to reaffirm that test of attribution, as opposed to what the International Criminal Tribunal for Yugoslavia did in the Tadic case, where overall control instead of effective control over the conduct was the criteria. That's it. I mean, this is the case law of the court. It is a criteria that is very generous for states and very difficult to meet for states claiming responsibility. And you remember also in that case that the court refused to, at a very late stage in the proceedings, to order Serbia to open its military archives at the request of Bosnia. Maybe there was a smoking gun somewhere hidden in the military archives of Serbia. We shall never know, okay? Whether there were instructions coming from Serbia to the Serbs on the ground, to the militia, to the Serb militia, the Bosnia Serb militia on the ground. So the court made that finding in light of the evidence produced in the case and in light also of the rules of attribution. And despite finding that the Bosnian Serbs were not, that Serbia was not responsible for the conduct of the Bosnian Serbs, the court nevertheless found that Serbia was responsible for the breach of the obligation to prevent genocide. Yeah. It's always difficult to second guess when you've not been in a case and when you are not yourself the judge with not, all the evidence, if that was the right or the wrong decision. It's certainly a decision that has been, that has been informing international law since then. Clearly, the criteria for attribution has been reaffirmed by the ICJ. Yeah. Other questions, dear students?
Thank you, Professor. I think we have 3 more minutes, and
Sure.
With your answer, you answered the question of Fernando.
Yeah.
We have here. There are another questions that we'll address it tomorrow.
Yes.
Tomorrow. And I think fine for today. And I'd like to thank you again for the lecture, and hope you see you tomorrow again.
We'll see you tomorrow again. Thank you very much, ladies and gentlemen, for your attention, and thank you, dear colleague, for your kind moderation of the debates. I hope I have not been speaking too much and too abstractly, but let's meet tomorrow indeed, and we'll continue with obligations of result and conduct and positive and negative obligations. Thanks very much.
Thank you, Professor.
Bye-bye.
It was wonderful. I'd like to thank Cedin, Professor Leonardo Brandt, and everybody that are hearing us and watching us. Thank you.
Thank you very much. See you tomorrow.
See you.
Bye.
Good morning, dear colleagues and students. May I have your attention, please? First of all, I would like to welcome you all to this virtual lecture about the International Court of Justice and Human Rights. My name is André de Carvalho Ramos. I'm a professor of international law and human rights at the University of São Paulo Law School, and I will be your moderator. Today, we are honored to have a lecture from Professor Bruno Zima. Before the presentation begins, allow me to introduce our lecturer. Bruno Zima is professor at the University of Michigan Law School, and he is a retired professor at the University of Munich. Also, he served as a judge on the International Court of Justice from 2003 to 2012, and currently is arbitrator on the Iran-United States Claims Tribunal. In the past, he was a member of the UN International Law Commission and also a member of the Committee on Economic, Social, and Cultural Rights. Professor Zima has more than 120 publications. Among them, I can mention the Charter of the United Nations, a commentary from Oxford University Press. I'd like to thank Professor Leonardo Nemer and all of the CEDIM team on behalf of Paula Neves for the organization of this exceptional seminar. Finally, the organization asked me to inform that this session of question and answers will be made only tomorrow after the presentation of the final part of the lecture. Without further delay, I would like to welcome our lecturer to deliver his presentation. Thank you again, Professor Zima. The floor is yours.
Well, thank you very much. Thank you and Professor Brandt in Belo Horizonte for this invitation. Just before we started, I remembered that I was in Belo Horizonte for a week in 2005, and I had a wonderful week with about 300 students, but also with a football game in that huge football stadium of Belo Horizonte and the steaks and all that. So I have a very, very fond memory. I don't even remember what I taught, what course I taught in Belo Horizonte, but I hope it wasn't what I'm going to tell you tomorrow, or today and tomorrow. Professor Alain Pelé, who is also going to be among the teachers in this course, once wrote a paper on droit de l'hommisme, the human rightism, which he considers as a pain in the neck, people that have lost touch with reality, people who are wishful thinkers. And then he counted a number of names. And I was among these names, but at least he kind of modified his judgment a bit by saying that Bruno Zima is a reasonable droit de l'hommiste. And I think that is a good description of what I am, because I really distinguish between my professional life and my private life. In my private life, of course, I fight for human rights when there is a chance. I help and assist. In the academic scene, I'm not a fighter. On the academic side, I'm more an observer, somebody who likes to look at the situation in which human rights and the general community, let's say international law, the traditional international law, meet and interact, and what kind of reactions this process shows. So I'm in a very different category from the human rights lawyers like your fellow Brazilian Cansado Trindade, who is a good friend of mine, but he's also a fighter and in his writings, and I'm more the guy who sits on the side and looks what happened. And so I'm going to tell you about my experiences with human rights and my impression of how human rights fare at the International Court of Justice. My interest in human rights was, let's say, I didn't start out as a human rights lawyer. I started out as a very bread and butter public international lawyer, more interested in sources, the law of treaties and stuff like that. But then in the mid-1980s, I was appointed to a new UN Human Rights Treaty body, namely the UN Committee on Economic, Social and Cultural Rights. And what I remember, and I spent 10 years with that committee, and what I remember is that I always felt a bit on the sideline as an international lawyer, because this committee consisted of economists, political scientists, a few lawyers, and a number of people of whose origins and whose, let's say, I could never get a clear picture of. And sometimes I felt in that committee that I had to protect international law against the human rights people. And then in the early 1990s, I changed from the human rights body to the International Law Commission. And my experience there was about 180-degree different. In the International Law Commission, I felt I had to protect human rights against the international lawyers there. Let's say the mainstream international lawyers in the International Law Commission, like former legal advisors or domestic judges, people like that, who had very diverse and, in my view, very problematic opinions on human rights. And so one of the things I managed in the International Law Commission was to keep the International Law Commission from taking up human rights topics during the time I was in the Commission. And I think the Commission has not really done much human rights work since then either. And then in 2003, I was elected to the International Court of Justice. And so I was very interested to see how would human rights be handled there. My plan for these two lectures is as follows. Today, I'll start with a very brief facts about the International Court of Justice from the viewpoint of my lecture. That is, what are the features of the ICJ which are of relevance to the ICJ's dealing with human rights? Then I'm going to give a very short introduction also about what I understand by international human rights, the international human rights system. And then I'll turn to the essence of my lecture, which is, of course, the ICJ and human rights. And there I'm going to divide this part of the lecture up into two chapters. The first chapters will consist of a tour d'horizon of the jurisprudence of the ICJ relevant to human rights, culminating in some extremely interesting cases decided in recent years. And I will conclude tomorrow by looking at the legal or political context or limitations for the ICJ in human rights matters. And of course, end with the usual prospects for the future. All right. So first, a few basic facts about the ICJ. I remember that Professor Brandt published or edited a huge book about the International Court of Justice in Portuguese. And I'm sure that in your classes you probably heard more about the ICJ than you wanted to hear. But just a few facts. What is very important to remember is the ICJ is an old court. It's now about 90 years, more than almost 100 years old. And this shows in many, many provisions of its statute and in the way it works. Of all the international courts around, it is the court that has most features of arbitration, that is, features of arbitration, and in that regard is a bit old-fashioned. Of course, you know that the ICJ cannot decide contentious cases without the parties having given their consent. And in many instances, in many cases, years will pass before the ICJ has made a decision whether it does have jurisdiction or not. So consent is at the very basis. And that, of course, is a huge difference compared to courts like the ones I know because I'm closer to them, like the European Court of Human Rights or the European Court of Justice of the European Community at the regional level. So consent is the basis. The states have to accept the jurisdiction of the court in a number of ways. If a state does not have a judge of its nationality on the bench. And of course, no state has quote unquote, a member on the bench, because the judges are independent, of course. But if there is no national of yours on the bench and you are a party to a case, you can appoint a judge ad hoc. I think Professor Candidato Dandaje was actually a judge ad hoc in a case, I think, right until he was appointed to the court. That, of course, is also an element that we know from arbitration, where the entire composition of the adjudicating body is in the hands of the parties. My impression of the ICJ was it's more a civil court. That is a court dealing with civil matters. The entire way it works is a mix of the continental Germanic legal tradition with the common law tradition. I would say, for the taste of common lawyers, a bit too much on the civil side. But a very important positive element is that, of course, this is the only court, international court in the world, which we can, if jurisdiction is given, deal with any question of international law. And of course, among these questions of international law, there are not just boundary questions, maritime delimitations, but also human rights questions. And to these I will now turn. But first, just to give you a few impressions about when we are talking about the ICJ and human rights. So what do I mean when I speak of human rights or international human rights? I have a very unphilosophical, very technical understanding of the matter. By international human rights, I understand the sum total of international legal norms, obligations to protect and respect human rights, obligations which derive both from international treaties, also from customary law. It's a body of international law in which the so-called soft law also plays a very important role. And secondly, I understand by international human rights also the institutions and the procedures by which these institutions deal with human rights by administering human rights topics, implementing human rights decisions, enforcing these obligations. And I'm not by coincidence mentioning enforcing at the very end, because genuine enforcement of human rights is still a very, very, let's say, underdeveloped element of international human rights. But the regime has grown into an impressive edifice, consists now of several dozens of multilateral conventions, many of them having supervisory bodies, the so-called treaty bodies. And we could, let's say, phrase or take as the name for this system, this is the treaty-based system, At the United Nations level, you also have what I would call the charter-based system. When you look at the United Nations, you see there is the Human Rights, the Council, and then around the Human Rights Council, which is like a beehive of institutions and persons, human rights rapporteurs, etc., dozens and dozens of people engaging in I would say, development, supervision and development of human rights by way of soft law instruments, by way of soft law pronouncements and the like. The entire system has been described in very, let's say, graphic terms by a good friend of mine who is actually not among us anymore, Professor Antonio Cassese. And I'm going to read what he says about this thing. He says, human rights operate as a potent leaven, contributing to shift the world community from a reciprocity-based bundle of legal relations geared to the private pursuit of self-interest and ultimately blind to collective needs, to a community hinging on a core of fundamental values strengthened by the emergence of community obligations and community rights and the gradual shaping of public interests. I think that is a very good description. In my view, human rights, international human rights, are a revolutionary phenomenon in international law, and at the same time a inherently paradoxical or contradictory element. What do I mean by that? First, human rights are a revolutionary phenomenon. Until a few decades, don't forget, until a few decades ago, international legal concerned of states, if they had concerns in that regard at all, relating to the treatment of their own nationals abroad, was the only thing that counted. States, with regard to what kind of protection, what kind of concern did states have about, let's say, individuals, was the concern of nation states about their nationals abroad. But the treatment of states by a state of its own nationals belonged to the very core of domestic jurisdiction, shielded by international law against foreign intervention. For instance, in the 1930s, there were observers observing the surgence of the, let's say, violent anti-Semitism and other violent developments in the Third Reich in Germany. But among the international lawyers, there was a consensus that the law did not provide for any, let's say, tool to combat this development. The law came in once foreigners were involved. But with regard to the Adolf Hitler and his regime treated the Germans, and among them the German Jews, was not the concern of international law. And states in that regard were like what the sociologists call black boxes. You saw the state, the diplomats popped out, the heads of state popped out, armed forces, etc. But what went on within the state was not the subject of a legitimate inquiry by other states. Now, this has really changed fundamentally. And today, the treatment of human beings by public authority has become the subject of international concern. I actually like the term international concern because it's more realistic than speaking of international protection. If you look around the world, if you read the newspapers, you see there's a lot of concern around. But if states, the step from concern to protection is a very difficult one. Just to give you one example, think of Hong Kong, think of the Chinese steps towards the, let's say, cutting the autonomy of Hong Kong, and see how difficult it is for other states to do something, let's say, of weight, of effect against these movements. Now, this international concern has led to what the lawyers call a droit de regard, that is a right for other states to deal with human rights developments in other countries by, for instance, discussing matters in international fora, by what at the UN is called naming and shaming of human rights violations, by what in the United Nations, where everything is very diplomatic and very soft, is called constructive dialogue in treaty bodies, where states present reports. These reports are discussed, and then expert bodies give their advice. What have you done well? What could you do better? So-called constructive dialogue. Then, of course, you have also binding decisions by international courts, like your great court in San Jose de Costa Rica, or the Strasbourg Court on Human Rights. But the real enforcement of sanctions are still more the exception than the rule. But just to, let's say in one sentence what I mean by the revolutionary character of the human rights movement, I think you can say this movement has turned the states insides out. That I find a very graphic but very, let's say, telling description. the international human rights law and movement is turning the states inside out. Now, I don't know what kind of families you come from, what kind of relations you have with your partners, etc. But you would agree with me that if the insides of your relationships are turned outside, you might get into a defensive mode, and you might not like it at all. And that is precisely what also happens with states. Every state, let's say, proclaims that it is in favor of human rights, that of course it is the mother of human rights, as France says, etc., etc. But there is a lot of resistance also. That gets me to the second point, that is, the international human rights are at the same time something inherently paradoxical or contradictory. Because despite all the international movements, the realization of human rights is still a profoundly national or domestic issue. Ultimately, and that might be of quite relevance to many of you when they think of their own environment, of their own state. Ultimately, only the people whose human rights are at stake can force the elites, the regimes, the government to respect them. If human rights are not part of the political culture of a society, they will have a very, very hard time, and they will be on very, very weak, let's say, ground. So, for instance, and that, of course, is a topic on which I could go on, but I don't have the time. But what is a fact is that international supervision, all the things, the treaty bodies, the Human Rights Council, the ICJ, all these international institutions and bodies can only, I would call it, check, reinforce, strengthen, encourage, or harmonize ways and means of securing domestic respect for human rights. And because I think this is so important, I asked Paolo to send you a picture. I hope you have received it. One of the things I love is ships. I love ships. And in my office, in my apartment in The Hague, I have this photograph that you should have gotten. I have it over my, let's say, on the wall. The supertanker. You see a huge bow of a ship, and you see that little tugboat trying to move that bow. You have these tankers nowadays, or let's say bulk carriers that are up to 400 meters long, 60 meters wide, and have a depth of maybe up to about 30 meters. I live in The Hague, and one of my favorite, let's say, little excursions is to go to Hoek van Holland, where you can see all the ships going in and out of Rotterdam harbor. And you look over this, and you see there is a place there where ships bring ore, that is iron, from Brazil. And these ships can only stop and unload their cargo. They can load their cargo in one place in Brazil, and they can unload it. The only place in the world where they can unload it is Rotterdam, because the depth of the seabed there has to be about 30 meters. The ships are so huge. Now, if such a ship, I have to move from ships back to human rights, I'm sorry. But if such a ship is to stop, it takes about 15 to 20 minutes for a ship to simply stop. That's where, for instance, in these international waterways like the English Channel, etc., maritime traffic is so dangerous. And I think this is a good paradigm for, you have the sovereign states like the supertankers. They are moving, they have their course, they have their, let's say, targets to go, their places to go. And it will take a huge effort, if any, for these ships to change their course. Take that as a paradigm for international system of human rights concern and the sovereign states. Because the sovereign states are not only them, of course, they produce human rights law, they conclude the treaties, but at the same time, they are also the ones that we look at least at the international legal discourse as the subjects whose activities are of concern to us. And you could say, so governments are at the same time the makers, but also the breakers of human rights. And for most countries, if not all countries, international concern for human rights in one's country is a permanent, to say the least, nuisance, up at the other end to a threat. And you can see in the behavior and the foreign policy behavior of a number of states, you can see how they react to these threats. I think that's what I'm going to say about what I have to say, just as a mini introduction to international human rights. And with that, I'm going to turn to the ICJ, and it's what in the field of human rights. And here I think two questions come up. First, has the development of international human rights has had an impact on the jurisprudence of the ICJ? And then you turn the question around and you can ask, has the jurisprudence of the ICJ had an impact on the development of human rights? And these are the two questions that I'm going to deal with for the rest of today and for tomorrow. And well, I've written a few papers about that, and I hope you haven't read them. Well, I mean, I hope, of course, that you have read them, as any professor. But so that what I'm going to say is not just a repetition of what I have written. In my papers, I have distinguished between two phases in the engagement of the ICJ with human rights. There is a first phase, which is a phase in which the ICJ displays a considerable restraint on dealing with the matter. And then there is a second phase in which the court shows a greater degree of readiness to take up human rights questions and decide them as you expect of a court. And I have to explain that this is not just the term phase is not just there's not just an element of time there, because it would be difficult to say from 1945 to 1970 the ICJ hardly said anything, and from then on it said more. It's more difficult than that. There's a weak, let's say, limb, and there is a stronger limb in the jurisprudence. And of course, the weak limb is fortunately more a thing of the past than the strong limb. But just to make clear that when I speak of phases, it's not just from year X to year Y. Okay, now let me just say a few things about the human rights in the first phase, in which the jurisprudence showed hesitation and restraint. When the ICJ was, let's say, built into the United Nations Charter system in 1945, and then in the first years of the UN Human Rights Commission, one of the topics was, what role should the ICJ play in this new human rights movement? And the British, it's very interesting, the British put forward in about 1946 or 1947 the idea, well, why not, let's say, bring questions, the difficult questions on human rights before the ICJ, and the ICJ could then, let's say, give its view on these questions by way of advisory opinions. And one observer said this was discussed and more or less cut into small pieces. So there was no enthusiasm about the ICJ, having the ICJ involved in this business. Why? And I think the main reason is that in the period of the Permanent Court of International Justice, between the early 1920s and World War II, the ICJ had displayed or had favored, or let's say applied, a very etatist, a very statist image of international law, had put a lot of emphasis on sovereignty. And so the expectation was, now that this new movement, which is directed against protecting individuals against their sovereign or sovereign action, what are we to expect of the court, who has always held sovereignty so high? And so the expectation was very low. But then there are a few little blinks in the early jurisprudence of the ICJ, which show that at least the people did not all share that view or want to continue that outlook at international law. For instance, I think which was the second case, the Corfu Channel case, Corfu Channel, one of my favorite cases, because again, it deals with ships, it deals with warships. The story was that Albania was accused of not having swept from its territorial waters, particularly the Corfu Channel, an international waterway between the Albanian coast and the island of Corfu. So there were still mines around from World War II, and a ship had hit these mines, and so the British sent a number of warships into the Corfu Channel and swept these mines by force, so it is by the threat of force. So this was very much for people like me, warships, blah, blah, blah. But in the middle of the decision, you find the ICJ saying, listen, every state is under an obligation to see to it that other states are not harmed by activities of that state, or are not harmed by a lack or a negligence that state, because there are obligations, and I quote, based on certain general and well-recognized principles, among them elementary considerations of humanity. So, I mean, this statement sits a bit like what the geologists call an erratic block in their judgment, but still it has its place. And I would not be surprised if it could have been at the idea or the great Latin American judge Alvarez, I think, at that time, for that sentence to end up in the judgment. Or then comes the next case I want to mention here is Barcelona Traction. Barcelona Traction, which is about the treatment of a foreign company which was in charge of electricity, etc., supply in Barcelona, and which was lost, which became the victim of one of the great crooks in the Catalonian, let's say, economy and history, and lost its property there. It was its property, and so a case was brought against Spain on Spain's treatment of the Barcelona Traction Light and Power Company. And this is a case which deals with if there is a company, a shares company, and the shares belong to nationals of one state, etc., who has the power to protect that company diplomatically? Is it the state, the home state of the company, where the company was incorporated, or is it the home state of the majority of shareholders? That means something very technical, pure international economic law. And then suddenly, at a very early state in the judgment, you come across a statement which says, okay, these are bilateral obligations between states. They run between Spain and, let's say, the home state of shareholders. And from these obligations have to be distinguished so-called obligations erga omnes. And then I quote, such obligations derive, for example, in contemporary international law from the outlawing of genocide, as also from the principles and rules concerning the basic rights of the human person, including protection from slavery and racial discrimination. And then full stop, and the rest of the case, a very long case, continues with questions of international economic law. and no mentioning of human rights anymore. And you just wonder, how did that sentence get into the judgment? And I remember in late 1980s, I invited one of the very prominent judges of the ICJ at the time, Manfred Lachs from Poland, for a lecture in Munich. And Judge Manfred Lachs did something which I'm not going to do in the course of my lecture, that is, tell stories which had to do with the inner life of the court and how decisions were made. But he very proudly said, who do you think was responsible for getting that statement into the Barcelona traction case? It was me, said Judge Lachs. But of course, at the time, he had a political reason to do that. The judgment Barcelona traction came out in 1970. And 4 years before, the ICJ had rendered a judgment in a case which was as politically incorrect, quote unquote, as you could be at the time, namely a case concerning Southwest Africa, which was, of course, let's say, a theater of war between the majority of the United Nations members and South Africa for many years. And in the Southwest Africa judgment, the court said, okay, there have been these two African states, Ethiopia and Liberia, who brought a case, a contentious case, claiming that the apartheid politics in Southwest Africa was in breach of the mandate system. But the court said individual member states that had already been around in the mandate system do not have the right to claim that breach. Only the League of Nations would have that right. And of course, the League of Nations wasn't around anymore in 1966. I remember I attended the Hague Academy of International Law for the first time in 1967. And I still remember the rumor, or just more or less, it was almost an outcry among the people there. What shame on the ICJ. And I remember that I was told that all employees of the United Nations, everybody had gotten a pay raise at the time, except the judges at the International Court of Justice. So there was a lot of, let's say, impatience and ire vis-a-vis the ICJ, and so Lachs took the opportunity and showed in Barcelona traction, well, there are some of us who think differently and who have a respect for human rights, and coined that phrase, obligations erga omnes, to which I will return. Then in 1981, for instance, you have the Tehran case, the United Nations on the treatment of United States diplomats and consular personnel. In Tehran, they had been taken hostages by the mullahs in Iran after the Shah had fled from the countries. Also very highly political. But what the ICJ says at some point, that hostage taking is incompatible with the fundamental principles enunciated in the Universal Declaration of Human Rights. So that much on that first group. That is, the ICJ mentions human rights, but it's really in a you could say an incidental way. Not much is made out of that statement. The statements are like little fires. They blink, but they are out again. Now, there is a second early cluster of human rights considerations in the jurisprudence that I'm also going to mention. And these would be early cases, let's say relatively early cases, in which the court deals with quite technical questions, really very technical questions, but these questions arise from or are linked to human rights situations or problems. So the court engages in a discussion of a matter which is very different from human rights proper, even though the subject might somehow be linked to human rights. And a case that probably many of you will know in that regard would be the case or the opinion, it's an advisory opinion, on the reservations to the Genocide Convention, which was the first human rights treaty adopted by the United Nations in 1948. And it provides for the jurisdiction of the ICJ, and we will get to these cases in quite soon. But at that time, this was also the time when the Cold War broke out, and a number of European countries, Eastern Middle European countries, became communist. And all these countries, Soviet Union plus the entire, let's say, group of followers, made reservations and excluded the jurisdiction of the ICJ, And this was, of course, countered by the Western countries under the leadership of some Latin Americans, actually. And they brought the General Assembly to ask the ICJ for an advisory opinion on reservations to the Genocide Convention. And if you read the opinion, of course, it deals with human rights. It hinges on the Genocide Convention, but what it then goes out to say is more on how are we going to deal with the reservations now that we have more multilateral conventions than we had in the League of Nations period. How are we going to deal with reservations to treaties that have a lawmaking function? The emphasis now should be more on universality instead of consent by all other members to a reservation and the like. So that's what I mean. A couple of years later, actually not a couple of years later, on a year beforehand, you had another advisory opinion on the interpretation of peace treaties with Bulgaria, Hungary, and Romania, where the question, you had these peace treaties, they looked very nice and and provided for protection of human rights, and also provided for, let's say, the possibility to bring complaints in case of violations. But then, of course, Bulgaria, Hungary, and Romania had turned into communist states, dominated under the, let's say, umbrella of the Soviet Union. And that meant the end for that protection system. And so some Western countries, the United Nations, brought the question before the ICJ, whether you could do a little less benevolent violence to the provisions on that protection. And the court said, unfortunately not. Unfortunately not. If a provision provides that it can only be used with the consent of the states, and there is no consent, that's the end of it. Even in the Nicaragua judgment of 1986, the big Nicaragua judgment, human rights are mentioned in connection with use of force, because the ICJ tells, particularly the United States, that the enforcement of human rights by the use of force is not an appropriate method. Just a sentence. And then you have in the late 80s and in the 90s, you have a couple of advisory opinions which had to do with the immunities of UN special rapporteurs on human rights, so-called Matsilu and Kumaraswamy cases. So I think, why does Sima mention that kind of stuff? Well, the threat which combines these cases is that they had to do with human rights. The court took the questions up, but then in the respective judgments or opinions, technical questions are dealt with, which have a much broader application than with regard to the human rights questions in point. And then, of course, you have a third group of cases in which the court developed the right to self-determination of peoples. Why do I mention self-determination in a presentation on the ICJ and human rights? Well, because you know that in the human rights doctrine of the United Nations, the realization of self-determination in the context of decolonization is regarded as the conditio sine qua non, as the condition for the enjoyment of individual human rights. So to just put it a bit more freely, without prior self-determination of these peoples, there can be no genuine, full-fledged individual human rights. And with the increase of decolonized, let's say, new member states of the United Nations with a colonial background, of course, the drive in the United Nations for also in the direction of the ICJ to deal with these matters became stronger and stronger. So you have already in the 1950s, you have a number of cases which had to do with the way and the possibilities for the United Nations to supervise the mandate system, which was still in force in South Africa and in Southwest Africa. I think you have three advisory opinions on the court on this matter, which of course on the ground did not help very much. Then you have the famous or infamous Southwest Africa case that I've just mentioned a few minutes ago. You have that, let's say, the attempt by the ICJ to free itself of that image. You have the Barcelona Traction, but then you have the an opinion on the legal consequences for states of the continued presence of South Africa in Namibia, 1971, where the court said that, for instance, the the gold and diamonds and the resources of Southwest Africa and Namibia are a property or belong to the people of Namibia and not to South Africa. And that has the consequence that if you Western countries, you engage in commerce with these, resources, you will be in trouble. You will be in trouble. And I think that opinion really had an impact on the further way that the question of South Africa developed. Then you have, I've just finished a number of cases, or mentioned a number of cases where on decolonization, you have the Western Sahara case, Western Sahara, in which the court more or less told the Spaniards that their dominance over the Western Sahara had come to an end, that the inhabitants, the indigenous population of the Western Sahara had a certain international legal personality. Then you have the East Timor case in 1995. You had the Portuguese moving out of their colonies in East Timor in the early 1970s. You had a liberation movement there, but before the liberation movement could establish its own state, Indonesia, as the regional, not superpower, but power, moved in, and you have decades of a fight against the regime by Indonesia. And a lot of crocodile tears being by Western countries. My God, Indonesia why are they there? They should go. But for instance, the United States being very happy about the relatively, let's say, reliable state of Indonesia dominant there instead of these proto-communists in the liberation movement. And in that situation, Australia concludes a treaty with Indonesia about the expropriation of the oil and gas in the so-called Timor Gap between Northern Australia and Indonesia. And that brings Portugal before the ICJ. And Portugal claims, among other things, that it is the responsible administering country. It is responsible for what happens there. And so there is Australia breached international law by engaging in that business with Indonesia. And the court, to the great disappointment of human rights lawyers, came out and said, well, there is something which we call the indispensable third party, which means I cannot find Australia in breach of international law before also before that, also finding Indonesia in breach. And Indonesia has not accepted the jurisdiction of the court, and that is the end. Thank you very much, full stop. 1995. Great disappointment. Then you have the Wall opinion, in which where I already was on the court, the legal consequences of the establishment of a separation wall on the occupied Palestinian territories of 2004. You have the Kosovo advisory opinion in 2010. And the last one, the very recent one, on which I'm going to say just a little bit more, would be the opinion that was rendered last year on the legal consequences of the separation of the Chagos archipelago from Mauritius, where the General Assembly asked the court to render an opinion on the question whether the process of decolonization of Mauritius was lawfully completed when Mauritius was granted independence in 1968. But before that, the so-called Chagos archipelago, a number of islands in the Indian Oceans, had been separated from Mauritius and was kept under British, jurisdiction. And the second question was, what are the consequences of what happened there? And the court came out and said, the process of decolonization of Mauritius was not completed in 1968. There is still the problem there of granting, of Great Britain just disappearing, moving out, and the Chagos Islands being able to, have their voice and more or less reunite with Mauritius. That was the idea. This was a very strong opinion, a great success for the third world countries. It's also politically a very, very tricky one, because one of the islands in the Chagos archipelago is an island. God, I can't think of the name, in which the United Kingdom granted the United States the right to establish a huge naval base with you find there warships, you find airplanes, you find nuclear weapons. Diego Garcia, which is one of these islands. And so, of course, if the ICJ says in an opinion, Great Britain, why don't you just disappear from there? That also means that the United States should probably disappear, is not an easy answer to, it's not an easy question to answer. And the reactions by the United Kingdom were, as you can imagine. Okay, so this is the first stage. Now I would suggest that we have a 5 minutes break. At least I don't know whether you need it, but I think I need it. So can we be back here at on your side, it's 11 o'clock sharp. Is that correct?
Yes, 11 a.m., Professor.
Oh, sharp. So we have about 4 minutes break, and then I continue. Okay.
Let's have a 5 minute break, guys. See.
Can I speak about so the audience is off now, or?
I don't think so. Let's see. Let's see. Okay. Professor, the floor is yours.
Okay, back to work. I now turn to the to my next chapter, which is really getting to the core of my lecture. That is, we now have, or in more recent years, we have had cases in which the ICJ dealt more fully with human rights questions and dealt with human rights questions in a more, let's say, at least in the majority of cases, in a let's say, satisfactory way. So let me just tell you what cases I'm talking about here. I think the first one in that row would be an advisory opinion again. So you will have noted that I also regard advisory opinion proceedings as cases in a non-technical sense. So this would be the case of the opinion on the legality of the use by a state of nuclear weapons in armed conflict, an opinion rendered in 1996. When I joined the court, I heard from my colleagues at the court who had been there at the time that no other case had seen so much actual fighting and fury than this case. Of course, you will know that the most interesting thing about the advisory opinion is that the court said it could not come to a conclusion as to whether the employment of nuclear weapons against an armed attack was a breach of international law, so very problematic. But the court also dealt with a number of the aspects of the case from a human rights viewpoint, namely from the viewpoint of a human right, international human right to life. But of course, it did not, the real decisive questions were use of force questions, actually. Now, the next case in point would be the Wall opinion. This was the first of the cases that I'm going to mention now, that where I was a member of the court. Also a very political case. And one of the points that the court dealt with was whether the construction of that wall had also led to human rights violations. Of course, under the circumstances, mainly violations of the economic and social rights of the Palestinians there, which by the wall were separated from their, let's say, agricultural fields and olive trees, etc., etc. So another point in question was that the court developed a bit further this concept of obligations erga omnes and rights erga omnes in the Wall opinion. So quite a bit on human rights. The next step was the decision in 2005 in a case between Congo and Uganda. There was what we call the Great Lakes Wars in Africa from the late 1990s into the early 21st century. And the Congo, the Democratic Republic of Congo, brought cases against its neighboring states who had all been involved in armed conflict on the territory of Congo, which the Democratic Republic of Congo wanted them to get out of their territory. They didn't. So that was more or less the political situation. And in the Congo-Uganda case, the court found, on the basis of reports by United Nations, commissions, investigations, that a lot of human rights violations and a lot of violations of international humanitarian law had occurred in that conflict between Uganda and the Congo. And this was the first case where, if you look at the dispositif, that actually the tenor of the judgment of the ICJ, you find for the first time in the history of the court that certain human rights, the courts find that certain human rights violations have occurred, that certain violations of international humanitarian law have occurred. So that, I think, is a step that needs some attention. Then After the Congo-Uganda case came a case against another neighbor of Congo, namely Rwanda, Congo-Rwanda, in which the court rendered a judgment in 2006. So there's really year after year now. And in the Congo-Rwanda case, the Congo complained or claimed that Rwanda had violated a whole range of multilateral treaties to which both it and Rwanda was a party. And one of these multilateral treaties was the convention, the Genocide Convention of 1948. But Rwanda had, when it signed up to the Genocide Convention, made a reservation excluding the jurisdiction of the court, which of course is remarkable. This happened after Rwanda had become the place where one of the most monstrous genocidal, let's say, acts had taken place since World War II. And this very country, Rwanda, excludes the jurisdiction of the ICJ to decide about such cases. But the court had already in earlier cases found that also reservations to the Genocide Conventions work like reservations do as they are desired to do by the reserving state, namely exclude the court from meddling in these instances. There had been a case involving no less than 10 NATO countries brought by Serbia, and most of these NATO countries did not have to appear before the ICJ because they had made reservations on how does the Genocide Convention come into a case between NATO and Serbia. Well, Serbia claimed that some of the ammunition which was used by NATO airplanes in their attacks on Serbia had an element of depleted uranium. I don't know what the effect of that is. It's not that by using that kind of ammunition, the states intend to employ, let's say, something nuclear. It's just that the depleted uranium has a certain effect, that increasing the effectiveness of the weapon. And so Serbia said, we have in our soil now, due to your attacks, depleted uranium, which is going to be a health problem for generations, and that is a violation of the Genocide Convention. Well, with regard, but the court did not really speak out about that question because of the reservations that had been made in that regard. And then came Congo-Rwanda, and the court said, well, we have to stick to our jurisprudence. You cannot conclude that if a treaty is as important, as fundamental under human rights terms, like the Genocide Convention, no reservations, including our jurisdiction, can be made. That would be desirable, maybe, but that is not how the law of reservations works. So Rwanda, let's say, Rwandan behavior cannot be looked at from the viewpoint of the Genocide Convention. This was very, very unsatisfactory to a number of members of the ICJ, among them myself, but also Judge Higgins, Judge Owada, Judge El Arabi. And so we issued a joint dissenting opinion. I think 5 judges issued a joint dissenting opinion in which we said, listen, the Genocide Convention is also a human rights convention. Of course, a very fundamental human rights convention. Now, all other more modern human rights conventions have at least treaty bodies sitting on them, and these treaty bodies will look into the question of violations. There will be a dialogue. There will be some kind of, let's say, not judicial activity, but at least some method to find out whether genocide has occurred or not. In the case of the Genocide Convention, the only treaty body, quote unquote, that you can find is the ICJ itself. So if you exclude the jurisdiction of the ICJ, that means you kind of take away from that treaty the only let's say tooth, that the only weapon that treaty really carries. And then, of course, this case, Congo-Rwanda, took place at a time when both the Soviet Union and all the other former communist countries of Middle and Eastern Europe had revoked their reservations to the Genocide Convention. So we said, this is ahistorically, and that has to be changed. But of course, reservations being made stay there. And as far as I know, none of the countries in question had revoked their reservation to the Genocide Convention. So Congo-Rwanda. And then come the big genocide cases against, first against Serbia, Montenegro. The first one brought already in 1993 against Serbia by Bosnia-Herzegovina, and the second brought by later brought by Croatia against Serbia. Let me say a few words about the first, Bosnia-Herzegovina against Serbia on genocide. I think that was a case in which Bosnia-Herzegovina really pursued a wrong tactics before the court. Well, maybe I should go a bit. I don't know how close you are in your memories with regard to the war in Yugoslavia, but that was a war in which Bosnia-Herzegovina had declared its independence, and that immediately led to Serbian forces invading Bosnia-Herzegovina, and later on the so-called Republika Srpska, that is the Serbian part of the population of Bosnia-Herzegovina, declaring its own state, having its own armed forces, and engaging in violence within Bosnia-Herzegovina. And so the question was, now what is this? Is this an international war, or is it a civil war within Bosnia-Herzegovina? And the UN and the International Criminal Court for Yugoslavia in The Hague regarded this as an international armed conflict. And of course, if there's an international armed conflict, you can apply much more effective IHL, international humanitarian law, than in case of a civil war. And so that was how Bosnia-Herzegovina looked at things. They said, what you see from Republika Srpska and Serbia is one huge violent act of genocide against us, one activity of genocide. The ICTY came to another conclusion. The ICTY came to a conclusion that there had only been one instance of genocide, namely in 1995 in Srebrenica. And you probably have seen on television, etc., that a few days ago there was the Memorial Day on Srebrenica. That is one genocide. And so the question for us at the ICJ was, this is a case that is brought against Serbia. So what did Serbia have to do with that Srebrenica genocidal activity? And the court came to the conclusion that, of course, the case could not be brought against Republika Srpska itself, but against Serbia. And Serbia's involvement was so that the regime in Serbia, in Belgrade, that Milosevic had not sufficiently tried to prevent that genocide from happening, had not engaged sufficient, let's say, power or influence on Mladic and Karadzic, the political and military heads of Republika Srpska, not to engage in these massacres at Srebrenica. So it was not found of a let's say, violator. It was not found to be an accomplice. It was only found to be in breach of, it had not applied enough due diligence to prevent. So that was about I'd say, the most lenient way for the ICJ to bring Serbia into the picture. In my view, it was an appropriate way. And I can tell you, it is not an easy thing for an international court, based on consent to its jurisdiction, all that, to declare that a certain state party to its statute has committed genocide, which is, of course, the most, let's say, condemning judgment that an international court could really render about the country. And we'll get to the current case on that in that matter in a second. So I think that was 2007, the Genocide Convention decision. Of course, the decisive problem with genocide is it's not enough for genocide to engage in, let's say, huge massacres. What makes a crime against humanity, a massive human rights violation or IHL violation, a breach of the Genocide Convention, is that if in massacring these 7,000 people at Srebrenica, you have a special intent, a so-called dolus specialis, which means to kind of annihilate the group, And in this Yugoslavia case, what the court said, what happened was ethnic cleansing. And of course, ethnic cleansing by terrorizing the population so they would move and probably go to Germany and leave the country to the Serbs there. But ethnic cleansing is not something pursued with that special intent to annihilate the group. You just wanted to move away, to move to some other place. And that was also the problem with the other Genocide Convention case that Croatia brought against Serbia, which had to do with the armed activities and violations of IHL committed by the Serbs in what would be northern Croatia, where also massacres had taken place, etc. But the court came out and said, unfortunately, it is not possible for us to determine that there was this dolus eventualis there. It was huge crimes were committed, terrible things were committed. And of course, behind that was hatred and more ethnic conflicts dating back to old times, etc., but not the intent to, let's say, get rid of an entire group of the population. Okay, Genocide Convention. Croatia against Serbia was actually decided in I think it was in the 2013 or 2014, around that time. Okay, right. Now that gets me, and I have to close the door because my family has arrived here. Just a second. If I don't lock the door, one of our grandchildren will come and more or less change the subject. So I now come to the core human rights cases since 2010. And the first one there is a case which is a little strange. It's the so-called Diallo case. This Diallo was a Guinean businessman who had invested again in the Democratic Republic of the Congo, the DRC. And he didn't fare well there. He lost his property and he ended up in prison. And then at the end, he was evicted from the country. And so Guinea, his home state, brought a case before the ICJ, which is strange because I remember already at the time, I thought, isn't that a case that would fit an investment tribunal, and where investors can sue countries in which they have made investments, and these investments are then taken away, or no fair and equitable treatment was used against them, etc., etc. And actually, it was a case actually built, but for some reason, Guinea decided to bring it before the ICJ. And in the ICJ, there was a first phase. At the end of that first phase, all the international economic aspects of the case, that is, how was the property? It was mainly container stuff. How was the property treated there? That is not our business, said the court. We don't have jurisdiction. And from then on, the Diallo case was a pure human rights case. And the questions before the court were, did the Congo breach the International Covenant on Civil and Political Rights? and other human rights conventions by putting Diallo in prison, by keeping him in prison, by not feeding him adequately in prison, etc., etc. That it would be conditions of detention and arrest, and then the expulsion of an alien. So those were the human rights questions that the court then decided in its judgment. The judgment was rendered in 2010, and what I find interesting about it is that the case would strike you as familiar, namely, isn't it a case of diplomatic protection where the home state of Diallo, Guinea, engages in protecting the victim of human rights violations in another country, a victim of its own nationality, namely Mr. Diallo? Yes, indeed. And of course, nothing is in the way of diplomatic protection. Is still a very important institution, and nothing is in the way of engaging in diplomatic protection by going before the ICJ, right? But then, of course, when we talk about diplomatic protection, you will remember the Mavromatis case, that is the basic case on diplomatic protection, in which the Permanent Court of International Justice had said in the 1920s already, diplomatic protection takes place when a state acts in favor of one of its nationals, but thereby protects its own rights, namely the right of the home state not to be violated in its right by what happens to its national. That is, Mr. Diallo, under that paradigm, would not be the real victim. The real victim would be Guinea, and Diallo would simply be the means by which Congo violated the rights of Guinea. And the ICJ, in its judgment, really dissects the case from the Mavromatis. It deals with the human rights violations of the person, Mr. Diallo, and not translates this into a violation of some state-to-state rights. And the only little remnant of the Mavromatis thinking comes out at the end when they speak of reparation. So that was after I had left the court. They said, what had Mr. Diallo, what had he lost, etc. They came up with a very modest sum compared to the sums that I deal with when I preside one of my investment cases, less than $100,000. And then the court says this money goes to Guinea, but would Guinea please keep in mind that Mr. Diallo was the one who suffered that injury? In other words, just hand the money to Mr. Diallo, and I hope very much that's where he got that money actually. So the interesting thing is that in the Diallo case, the court looked at the human rights and engaged in a determination of breaches of the human rights of an individual, not through that fiction of Mavromatis. And another thing which is interesting is that was the first case in which the court also mentioned or referred to decisions of UN human rights treaty bodies, and I think even of the European Court of Human Rights, which is very interesting. And because the court, when you look at the judgments of the court, you see that the court is very, very selective in what he quotes, in what the court refers to and quotes with regard to cases. I remember once, and that will lead me to the end of my class today. I remember that I was in the drafting committee in another case, and I come up and said, I found a very interesting case of the ICTY that we could use here. And then the registrar looked at me and said, well, Mr. Sima, we never quote other international courts, which has to do with that self-perception that we are the highest. And so we don't have to refer to these lowly creatures, ICTY, and so on and so on. But in Diallo, that limitation was broken. And of course, that was a consequence of the genocide case, because in the genocide case, one weakness of the ICJ was, of course, shown in great clarity, namely that the ICJ has no independent fact-finding capacity at all. fact-finding by the ICJ is something, the ICJ sits there and it relies more or less on what the parties put before it. And with regard to the genocide, that was, of course, a special problem. But in the genocide cases, what you had was the jurisprudence of the International Tribunal for the crimes committed in Yugoslavia. And while when you look at the court's judgment in the genocide case, you see the court behaves as if it had engaged in fact-finding. But what it does, it really refers to and relies on what the ICTY had found. Good. I think I stop here. I have 2 or 3 minutes to go. Well, maybe I can, I just deal with one more case. So, Diallo was a very promising case, you know. And then came a case which was decided in 2011, which really disappointed me severely. And that was a case brought by Georgia against Russia. Georgia in 2008 became the theater of an armed conflict with Russian troops moving into Georgia and parts of Georgia having already been occupied and more or less detached from its territory by violence by Russia. And that led to claims brought by Georgia against a number to the European Court of Human Rights and also to the ICJ. And Georgia claimed violations of the International Convention against all kinds of racial discrimination, because said Russia had more or less displaced persons of Georgian nationality in favor of Russians, etc., etc. It was a bit of I think the link that led to the jurisdiction of the ICJ was a very weak link, actually. But the court grabbed it. The court rendered provisional measures in October of 2008 that were regarded to both countries and said desists from these activities. But a few years later, the court came to a negative conclusion about the jurisdiction, because it said, when you look at the third convention against racial discrimination, you see that the way to the court is only open when a state has made a sufficient attempt at engaging in a peaceful solution by negotiation. And that has not been, that Georgia was not able to show in the court majority's view, which I did not share. So I wrote a long separate opinion and joined a dissenting opinion. And the Georgia v. Russia case is still the court that I like least of all the cases I had at the ICJ. That gets me to the end. Tomorrow I'm going to continue with a more, let's say, promising and cases like Belgium against Senegal, and also the Myanmar case, etc., etc. So I hope that will keep you interested in what I have to say. And for today, it's obrigado. And I'll see you again tomorrow.
Thank you, Professor Bruno Zima, for showing us at the beginning 3 groups of relevant cases in which human rights considerations occupied somewhat more space in the jurisprudence of the ICJ, or in which the court developed the right of self-determination of peoples. It's very important. Also, Professor Zima showed us that at least in the last few years, the ICJ has turned to decide cases focusing on human rights violations, at least allegations of human rights violations. And this review of the court's jurisprudence is very important, has shown a growth in the number of human rights related cases. And I think that everyone here, we are expecting more tomorrow. I'm grateful, Professor Zima, for this instigating lecture, which will certainly generate much reflection for the students who are seeing us. Dear colleagues, dear students, finally we come to the end of the first part of the lecture. We will leave the questions for tomorrow. Thank you all for your attention. Bye.
Okay, thank you.
Paula.
Well, good afternoon. I think it's time.
Okay, should I start to speak?
I think I have to introduce you.
Yeah, okay, okay. Please do.
I think it's time.
Okay, should I start to speak?
I think I have to introduce you.
Okay, please do.
I think there's a delay, so after we speak, we have to stop. There's a delay, so after we speak, we have to stop. Well, good afternoon to everybody. There's a delay, so after we speak, we have to everybody. Ah, I see. I have. Well, good afternoon to everybody. It is a great pleasure for me to introduce Professor Pierre-Marie Dupuy, who is an emeritus professor at the University of Paris, Panthéon-Assas, and after being a visiting professor in several universities, including Ann Arbor, Michigan, Professor Dupuy was on leave from Paris between 2000 and 2012, and was a professor at European University Institute in Florence and at the Graduate Institute for International and Development Studies in Geneva. Professor Dupuy is one of the founders of the European Journal of International Law, and a very important journal of this area, and has also led a double career as a scholar and a practitioner, and has written in almost every field of international law, including the general theory of international law, human rights, the law of international protection of the environment, and international investment law. He's also the author of a renowned textbook in international law, Le Précis de droit international public, which is now in its 14th edition. And as a practitioner, was involved in more than 20 cases before the International Court of Justice, being an active arbitrator as well for the ICSID, the PCA, and LCAA, and was the president of the ABA International Tribunal. Professor Dupuy is fluent in 5 languages and was awarded the 2015 American Society of International Law, mainly Hudson Medal, and is a member of the Institut de Droit International. He was also a professor in the Hague Academy of International Law, having done the general course on public international law in 2000. Today, Professor Dupuy will talk to us about 20 years later, how international law has evolved as a legal order. And I don't want to keep you anymore from having the pleasure of hearing Professor Dupuy. Professor Dupuy, please, you have the floor.
Dear colleague, I thank you very much. It's an honor and a pleasure for me to be at the same time here in Europe, in southern part of France, close to Nice, and in Sao Paulo, in Brazil. That's thanks to modern technology. The title of this lecture was chosen by myself. It's 20 years later. For a Frenchman, this is a way to ironically refer to a rather famous novel, French novel of Alexandre Dumas. The novel, 20 years later, is simply the follow-up of a very known book of Alexandre Dumas, which was The Three Musketeers. And this novel explains what happened 20 years after the end of the adventures which were told by Dumas in his first novel. The reason why I chose this title is because I delivered the general course of international law at the Hague Academy, as you rightly said, in 2000, exactly 2000. It's been 20 years ago. And I found it as an interesting challenge to review the theory that I developed during that period 20 years ago, in order to see whether the actual practice of international law during this time confirmed or, on the contrary, contradicted what I had taken the risk of explaining in my theory. I'll come back on it very soon. What I would like just to make more precise is that I shall speak of international law as, in technical terms, as a legal order, in the sense in which it was developed in particular by Hans Kelsen, by Santi Romano, by Georges Sell, or of course by Hart, who is particularly well known. Under this concept of legal order, let's start with a very general attempt to define it as an organized set of norms, establishing at the very least the way in which those norms are created and modified, as well as the relationship between the rights and obligation of the subjects to which they apply, and the consequences attached to their violations. Of course, there could be other elements to be put into the definition of what is a legal order, but I don't have time here to develop that. Well, when I delivered my lecture 20 years ago, it was a very nice time. Of course, for me, because I was 20 years younger than now, but also because 2000 was not only the beginning of a new millennium. It was a time when you could be relatively, reasonably optimistic as to the future and progressive development of international law as a legal order. That was a time when the Earl Grey round, which has established the World Trade Organization, was ended, and the WTO was already actively trying to reorganize the multilateral regulation of international trade with, as you know, an element of quasi-judicial control which had been introduced by the Earl Grey round. 2000 was also a time when, looking back to the beginning of the earlier decades and to 1998, when the new Rome Convention was adopted, one could see that a new development had been achieved, that of international criminal law, and the possibility to affirm that the individual is not only a passive subject of international law, but that the individual person can also bear international responsibility for the commission of international crimes as they are defined in the Rome Convention of 1998. And that was, of course, promising. Moreover, the Security Council had demonstrated during the 90s that due to political reasons, the United Nations was, or had been at least for a short period of time, able to develop, enlarge, expand the very scope of the maintenance of peace. And I refer back, for instance, in particular to the very stimulating agenda for peace, which had been adopted by the Security Council on the reports of its General Secretary of the time, who was Boutros Ghali. And finally, at the end of the 90s, the United Nations had been even given a very specific mandate, which so far it had not had an opportunity to practice, which was a territorial mandate on Kosovo. That brought some new difficulties. It was not a full success, but in any way, it was a demonstration that the United Nations, as the world organization, had a great potential to organize in a much more convincing way than in the past international peace. So I took this opportunity in 2000 for developing my own theory of international law, which basically is aimed at demonstrating that, contrary to what too many people said at that time, and for some of them still are saying now, international law as an international order is not fragmented. I insist on that. It is not fragmented. And why am I a bit, I don't want to be arrogant, but why am I so sure to say that? Because what I said in 2000 has been demonstrated to be true. We still have only one international legal order. And that was, at that time, there was a confusion between two distinct phenomena. One being complexity and complexification of international law, because a number of new fields of international relations were and still are covered by international law. Confusion between this complexification and fragmentation. There is no fragmentation because there are still two principles of unity of the international legal order. Two principles. Is that not a bit too much? It would be better, perhaps, or more efficient if we had only one principle of unity. Yes, in an ideal world, perhaps, but we are endowed with two because such was the will of states. We are endowed with two kinds of unities. The first one is a very old classical one. It is formal unity, and I will explain what it is. And the second is a very new one in historical terms, because it was only created on a very precise date, which is 1969. It is material unity, and I will explain what I mean by that. Yes, indeed, delivering the general course of international law in 2000 was a jolly good opportunity, perhaps not as provocative as the new adventures of the Four Musketeers, because there were four and not three in reality, or at least in the novels of Dumas. But it was really interesting to share with the audience of my lecture in The Hague, where I saw this unity. Now, what I shall tend to do now is simply, first of all, in the first part of my presentation, to explain the theory of the two foundations of the unity. And then in a second part, I will confront the theory to what effectively happened from 2000 to now, till now. Now, let's first begin by explaining in a bit more detail this dual unity, and I start with the formal unity. Formal unity, I can be relatively short because it's, as I already said, a very old and classical and well-known one. It was the one which was refounded in some way by the two famous Westphalian treaties during the 17th century. But basically, you could go much further back in the history of humanity to find the formal unity of international law. When I was professor in Florence at the European University, I was happy enough to live quite close to the fantastic Archaeological Museum of Florence. And there was an exhibition, precisely when I was there, about the Treaty of Kadesh. I enjoyed it very much. I went to the Archaeological Museum at least 4 times. Why is that? Because that Treaty of Kadesh dates back to 1270 before Christus. Realize what that means. 1270 before Christus, because it was a treaty passed between Ramses II, the big pharaoh, the most well-known, if I can say so, and Hattusili, the emperor of the Hittites. And it dealt with Syria. Already at that time, Syria was creating international problems for peace. And that treaty, I could read it at the Archaeological Museum because it was written and transcribed, of course, in several languages, and had been translated. And it was a treaty like we are used to read them, with a preamble, a set of articles, concluding paragraph, and it was formulated in a classical modern way, so to say, which is a way to demonstrate that the way how to create obligations in international law was not really renewed during over millenniums. And I spoke of treaties, but I could say the same about customary international law. And by the way, it is interesting to see that treaty law is at least as old as customary international law in terms of history. To put it in a nutshell, what is the formal unity of international law? It is the unity of the technology of its norms. Formal unity is composed of secondary rules of international law as they are defined by Hart in his very famous book, The Object of Law. The legal order, for that. Now, this formal unity was and still remain, for much of it, the same. I will come back on that in my second part. What is the material unity? The material unity is very different because, first of all, it is very new. Very new, of course, in historical terms. You don't need to get back to 2 millenniums before Christus. No, you find it only, as I already mentioned the date, in 1969. What is 1969? Of course, you already recognized the date of the year when the International Convention on the Law of Treaties was adopted in Vienna. And as you know, the Convention on the Law of Treaty contains a series of provisions, including one which is stated at Article 53, which I think is worth to be cited again so that you keep it in mind. Article 3, the title is Treaties Conflicting with a Peremptory Norm of General International Law, Jus Cogens. And the provision lays down a treaty is void if at the time of its conclusion it conflicts with a peremptory norm of general international law. For the purpose of the present convention, a peremptory norm of general international law is a norm accepted and recognized by the international community of states as a whole, as a norm for which no derogation is permitted and which can be modified only by a subsequent norm of general international law having the same character. So, two very important elements in this provision. First, peremptory international law does not fall down from the sky. It is the reflect of the acceptance of states. So we remain in a voluntaristic framework, the basis of obligations for states remaining in a very classical way, agreement of states. Second, Article 53 speaks of the international community of states as a whole. Community of states. How well can say a number of skeptic minds. Community, international community. We know this expression, and we know that in reality there is no real community. Just a second, please. Just a second. We are among lawyers. Are you familiar with the notion of legal fiction? What is a legal fiction? A legal fiction is something which has perhaps not much to do with facts, but which is a true reality in law. When international law says that every state are equal, it's a legal fiction. They are not equal in economic or in military terms. We all of us know that, but legally speaking, they're absolutely equal. It's a legal fiction. When you say in Brazilian law, as we say it in French law, that nobody is supposed to ignore what is the content of the law, we all know that it is not true, even after our very systematic studies of law. We don't know the law in all its details. But as a legal fiction, we have to start from the fact that every citizen knows the law. So there is nothing more true in law than a legal fiction. Another issue is to know whether in reality the international community exists, because I would tell you the answer is a moving one. There are some issues, some topics, some periods during which the international community of states, and not only of states, but also the international community, including NGOs and the civil society, concur in agreeing on sharing the same views and the same values. Because what is important is that material unity has taken the risk of being established on the basis of values incorporated into the law by the community of states as a whole. And the community of states as a whole is, so to say, the legislator of those peremptory norms. Now, this is brand new as compared to the formal unity. Formal unity is not hierarchical. There is no hierarchy between treaty and custom. But there is a hierarchy between peremptory norms and only compulsory ones. You cannot derogate the first. You can establish derogation to the second. So you can see that there is nothing more different than the two kinds of unity, and that, of course, at a certain point, there could be a conflict among the two of them, and I shall get back to one case in which I was involved as a counsel for one of the countries. It is the case of Germany versus Italy, 2012, where the court was confronted to kind of a conflict between perhaps not formal and material unity, but even worse, between two conflicting elements of material unity. We will come back on that later. Now, I think it's time for us to get to the second part of this presentation. Now that you have, I think, more or less understood my distinction, I recall that, of course, as every general course of international law, the course that I delivered in 2000 has been published in the Recueil de l'Académie Internationale. It is in a Latin language, written in a Latin language, just like Portuguese language is. And this Latin language, which still remains the other official language of the International Court of Justice, is namely French. So I encourage you to read French, even if you believe that you cannot speak it. Anyway, second part, the theory of the two foundations of unity put to the test of reality since the year 2000. Well, this period began in a very tragic way. I refer back, of course, to what happened only one short year after the delivery of my lecture, which was 9/11. 9/11 was the start of the globalization of Islamic terrorism and demonstrated that this community, not only of states, but also of people, was threatened by private groups, or for some of them groups which were maneuvered, controlled, sometimes by states, which are terrorists. Currently, we speak less of terrorism because of the pandemic, which is another way to experience the globalization of the world. But international terrorism will get back and is still one of the worst challenges. Now, let's go rather quickly through those two kinds of unity, formal and material, in order to see what are, in my view, we can discuss that afterwards, the main evolutions. As far as formal unity, I will be short. I would say there is not much to be said, or there is to be said, but basically, as I experienced it as a practitioner, the way how to deal with the law and international law in particular remains the same when you are a counsel before the court or an arbitrator within the ICSID, for instance. You deal with norms according to what the secondary rules establish as to the control and management of primary rules. Now, still, I would mention an interesting evolution which concerns secondary rules, namely the international responsibility of states. And international responsibility of state belongs to secondary rules, according to Hart's distinction, because the responsibility is second to the violation of primary ones. Okay. What is interesting is that during that very period, 20 years, there was an important evolution in the fact that the international responsibility of states does not deal only with the past, as it did it earlier, but also with the future. With the future, how is that? It is because of what the International Law Commission under Article 30B of its draft said when it indicates that the state responsible for the internationally wrongful act is under an obligation, if it is a continuing breach of the law, to offer appropriate assurances and guarantees of non-repetition, and non-repetition belongs to the future. And thanks to the way in which states, a series of states presenting that case before the ICJ during those 20 years, very quickly the transfer from progressive development to positive international law was realized thanks to the case law of the ICJ. Look to the Lagrand case, Germany, United States, Cameroon, Nigeria, land and maritime boundary, Avena, Mexico versus United States, armed activities on the territory of the Congo Democratic Republic, Congo, Uganda, genocide case, Bosnia and Herzegovina versus Serbia, two cases between Nicaragua and Costa Rica, the pulp mill case between Argentina and Uruguay, the jurisdictional immunities of the state case between Germany and Italy, are cases in which you can find that first one of the claimants and then the court accepted to say that in the case of the establishment of the violation of a primary rule by a continuous wrongful act, the court, the country which is responsible must offer guarantees of non-repetition. That is important because in a way it's an enlargement of the scope and field of the international responsibility of states. Second, I would like to mention an important element also, which perhaps I won't have time to develop very much here, which is that we did not make very many progresses, much progress, let's say, in the differentiation between the international regime of two kinds of liabilities, the one which is the result of the violation of their obligations, and the one which is and which should be aggravated constituted by the violation of a peremptory norm. And that is perhaps not that much the fault of the court itself, because if you, once again, if you get back to the very interesting draft articles of the ILC, you will see that the reading of Articles 42 and 48 does not provide any comprehensive and substantial legal differentiation of regime for the two situations. I have no time to go further, but I wrote an article on that in a book which was published under the responsibility of Professor Antonio Cassese, which I think is a very important one, which is called Realizing Utopia, and deals with what could and should be the future of international law as a legal order. Let's now, in the second subpart of the second part of this lecture, about the evolution of the material unity, the evolution of that kind of unity of which I told you that it was such a revolutionary one as compared to the former one. Well, it's basically a question of opinio juris. Whether a norm is interpreted as simply compulsory or as imperative depends on what the entity which will qualify it consider as to its social importance. Yes, indeed. Qualifying a norm as peremptory has a political dimension, a political potential. And this is one of the cases where you can see that this new kind of unity is a principle of unity, but at the same time is full of potential conflicts, because the way how to consider whether a norm is socially important or not has much to do with ideologies, with the Weltanschauung, with the vision of states, and not all of them agree about this. To say the minimum. Now, we deal now with the substance of rules, material unity. And there we find an interesting provision back into the Vienna Convention on the Law of Treaties, which has been established, as you all know, if you are already well trained in international law, which is to be found at Article 31(3)(c) of the Vienna Convention, which indicates that the interpretation of any treaty obligation should be, if needed, interpreted in the light of, I quote, any relevant rules of international law applicable in the relations between the parties, which is far-reaching. It means that you, at least in some cases, in order to establish and define precisely what is the content of a treaty obligation, for instance, Brazil in a bilateral treaty with Argentina, you would have to look not only to what the provisions of that bilateral treaty say, but also to other provisions of other treaties to which the two of them are parties. For instance, the Inter-American Convention on Human Rights. Brazil and Argentina are for the two of them parties to that convention. And then if you apply 31(3)(c) of the Vienna Convention, you could be confronted, or the judge at least in particular, could be confronted to the necessity of verifying how to interpret the provisions of that, in my example, bilateral treaty, taking into consideration the much larger obligations set out in the Inter-American Convention on Human Rights. So it's far-reaching. And some of the most advanced scholars say, and I'm referring in particular to my colleague Campbell McLachlan, who was a member of the ILC at the time when the project on fragmentation which led to no real convention, was examined by the ILC. Campbell McLachlan said, oh, but we are here endowed with a real principle of normative integration, an integrative principle, which is the best way to avoid the fragmentation of international law, which is a true principle or rule within material unity to guarantee this unity, this substantial material unity. Now, just a moment. We have to see what the international judge, limiting ourselves here with the ICJ, did with this provision. And to be short, the court used it in several cases, about 6 of them, but in a limited way. For instance, I can give you an example. In the case between Djibouti and France in 2008, the agreement between the two countries was, for settling dispute, was interpreted in the light of the Convention on the Law of the Sea, to which the two sides were and are parties. But one could hardly say that the court did a very systematic or even less systemic use of this potential principle of integration. And there is not much surprise about this. It is because the court is composed of a bench of lawyers coming from different legal cultures. They very much tend to limit themselves to what the statute, which governs them, say. And Article 38 of the statute of the International Court of Justice points to the, as much as possible, the obligations which are directly involved at stake for the settlement of the dispute. So let me just conclude on that. I cannot be too long by saying, yes, indeed, 31(3)(c) is a tremendous potential for guaranteeing, if developed by the judge, the integration, the normative integration of international law. But so far, the court has been very careful. And knowing a little bit the court from experience, I would tell you, I think that its trend will be to remain rather careful with this. Now, in the sense that qualification of a norm in order to decide whether it is compulsory or much more peremptory, which means non-able to be derogated. Qualification is part of interpretation, and interpretation is, once again, first of all, the role of the judge. The internal judge, by the way, as well as the international judge. And it is extremely interesting to see how since the entry into force of the Vienna Convention or the law of treaties, municipal judges, starting of course with constitutional judges, have used, but not only constitutional judges, have referred to this hierarchy, this normative hierarchy of norms in international law. Now, to be concise as to the overall review of the court's jurisprudence during the last 20 years, I would say that there is a paradox. First of all, we had to wait until 2006 and 2007, 2006 on activities on the territory of the Congo, Rwanda, and then 2007, the genocide case between Bosnia and Serbia. We had to wait until then for reading in the texts of a judgment by the court that there is at least one norm which is peremptory in character. And that norm was the prohibition of genocide. The paradox is that in reality, the court, I'm speaking not of the permanent court, but of its successor, the ICJ, almost since its very start in 1949, had already begun by using this hierarchy of norms. Speaking, for instance, in the Corfu Channel case of elementary consideration of humanity, or in the 51 advisory opinion on reservation to the Convention on Genocide, to obligations which are compulsory even for those states which have not ratified the Convention on the Prohibition of Genocide. Or the 1986 very famous Nicaragua-United States case, where the court points to the cardinal obligations of humanitarian law. Or 10 years later, the 1996 advisory opinion on the legality of the threat or use of nuclear weapons, to see that the court speak of untransgressible principles of international customary law. Because, of course, peremptory norms belong to customary international law. And in 2004, the very interesting advisory opinion on the war in the occupied Palestinian territory referred back to this qualification of intransgressible principles of international law. In other words, you had already the reality of peremptory norms recognized by the court before 2006 and 2007, but without saying it. In some traditions, religious tradition, you cannot pronounce the name of God. Here, it seems like if the court had difficulties to pronounce the name of peremptory norms, even if, as I said earlier, peremptory norms don't fall down from the sky, but grow out of the agreement of states. Now, among the very many cases in which I was involved as counsel, one of my most recent cases was the case between Germany and Italy. I had difficulties to convince my wife that I could accept to be counsel of Italy because my wife is German. and because I had twice been counsel for Germany in the Lagrand case, Germany won, and the certain expenses, not certain expenses, in the Liechtenstein, Germany. But to be serious, that was a very interesting case. And I accepted the offer by my good friend and illustrious colleague, Luigi Condorelli, to be Consul of Italy. We knew from the start that we could not win the case. And by the way, if you lose a case, it does not mean necessarily that you were not a good advocate. It may also mean that you could not win the case because the conditions were not put together to win it. And here we had a situation in which we could not gain the case. And if we had another case of that kind, we could not either win it. Why is that? Because there was a conflict. I announced that at the beginning of my lecture. There was a conflict between two kinds of norms. On the one hand, the sacrosanctity of the equality of states. Jurisdictional immunity of a state before the national courts of another state. Immunity. A Brazilian court cannot accept to judge another sovereign state because there is a principle of immunity. And this principle derives from a quasi-constitutional principle of the legal order, international legal order, which is the equality of states. Now, on the other side, you had the principle according to which you must respect fundamental principles of humanitarian law. Because what was at stake was the fact that former victims of the Nazi regime had never received any kind of repair from Germany, although they had asked for it several times. And the court was confronted to that. And we knew as defenders for Italy that we could not make it because of the principle of equality, or the principle of immunity of jurisdiction, which directly derived from it. But we had at least the hope that the court would open a little window by saying that in the future, under certain conditions, and if the practice of state could indicate this direction, one could consider and so on. Nothing of the kind. Now, you will tell me, but Professor, you seem to forget that only a few months later, on the same year of 2012, the court spoke again of international peremptory norms. And that time in a very positive way, because it said that the locus standi of Belgium was based on the very nature of the principles which were at stake, which is the prohibition of torture. Prohibition of torture established by a convention to which both Belgium and Senegal were and are a party. And the court did that, rightly so. And this is important. But you cannot compare the two cases. And I repeat, if you come back to the court with a kind of situation like the one in Germany, Italy, no hope to win the case on the part of those the tribunals of which have accepted to know of a case in which another sovereign state is concerned. Here in the Belgium-Senegal case, what was at stake was simply whether Senegal was bound by this obligation. Pacta sunt servanda. But the court did much out of that, because the court wanted to send the message that it did not forget what is the importance of peremptory norms in the international legal order. And that is a motive of hope, which was in some way confirmed very recently, even if it was soon only at a procedural phase, which was the case of Gambia, which deals with the Rohingyas. Gambia against I'm lost now. Myanmar. Okay. But so far, this case is at the very beginning of its development. The court simply accepted to know of or to deliver provisional measures because of the very nature of the rights involved, the breach of which being able to create an irreparable damage, which is one of the conditions of acceding to the claim. Now, I conclude by saying that, yes, indeed, material unity and the qualification of norms depends of the judge, but also of the states. And what did the states during the last 20 years? For some of which, very good thing, but for much the worse. We have seen in the past, from part of important states, which you will easily recognize, annexation of territory by force, which is clearly incompatible with the UN Charter and which is a breach of peremptory norms. No reaction or just condemnations, but oral condemnations. We have seen and we are seeing a number of cases where multilateralism as a principle, which means international solidarity among states, is being systematically attacked, starting again from a limited and narrow vision of nationalism and territorial sovereignty. And I wrote an article on one aspect of that, which was recently published in the Brazilian Journal of International. I don't leave that up here. And even during the COVID-19 pandemic, we have seen that once again, an important head of state criticized multilateralism and decided that USA would not be anymore a member of the WTO. It is not my case here to say that the World Health Organization, World Health Organization has done everything in the right way. But what is at stake? She, as a condition for the maintenance of the material unity, is precisely the respect of solidarity. Now, I'm still, nevertheless, rather optimistic because of the demonstration of concrete condemnations of this position by the largest majority of countries. And it is important in that respect, of course, to read every day the newspapers, which I recall was considered by Georg Hegel, the German philosopher, as a new way to pray every day as a member of international community precisely. Now, solidarity as the basis of the material unity has received only 5 days ago a wonderful homage by a Portuguese-speaking, very eminent person for whom I have the greatest admiration. I'm speaking of the Secretary General of the United Nations, Mr. Guterres. Let me end this lecture by calling what he said on the opportunity of Nelson Mandela's anniversary of days. I quote, "As Nelson Mandela said, one of the challenges of our time is to reinstill in the consciousness of our people the sense of human solidarity. The COVID-19 pandemic has reinforced this message more strongly than ever. Today, in demonstrations for racial equality, in campaigns against hate speech, in the struggles of people claiming their right and standing for future generations, we see the beginnings of a new movement. Will we succumb to chaos, division, and inequality? Or will we right the wrong of the past and move forward together? We are at a breaking point, but we know which side of the history we are on." I thank you.
Thank you, Professor Dupuy, for a very enlightening and with this touch of the present at your ending. I have here a few questions by the students that I wrote, but also I would like to start with asking you about the court, the International Court of Justice. I just wanted to say that by chance, I was at The Hague when the hearings of the case of Liechtenstein in Germany for the portrait was on. And I walked in and I sat for an hour or two, and Crawford was talking about the Sleeping Beauty, and his cell went on, and it was such a riot that day. And you mentioned the role of the ICJ in a few cases on your lecture, and started a comment on how the court has been careful on interpreting the Vienna Convention. And you have a particular and profound notion of the work of the ICJ, and 20 years ago as well, you wrote on the status of the international legal system and the role of the ICJ. At that time, you noticed the fragmentation of the court system and the lack of guidance from the ICJ into international law as a whole, especially because at that time, new courts were coming up as International Criminal Court, and we have more. At a certain point, there was only the ICJ, and now we have a series of courts with particular jurisdiction. So how do you think the court, the ICJ, has evolved in this last 10, 20 years? Do you think the court has assumed a central role, as Professor Ortega Vicuña and Christopher Pinto report pointed out? And if you want to say anything about the specific composition of this court of today, because you mentioned a few cases of 2006 and 2007, and you mentioned that the court has a certain composition at that time. Do you think it makes a big difference, the composition of today in the role of the ICJ?
I thank you very much for this very and multiple
Too big.
Interesting and multiple questions. Let me start by saying that you kindly refer to an article which I wrote in 1999, which was just before the delivery of my lecture. And at that time, the president of the International Court of Justice, who was a Frenchman, Juge Gilbert Guillaume, very eminent and qualified, delivered a speech at the annual session of the General Assembly of the UN, as every year. And he was the one in 2000 who insisted on the danger of having a fragmentation of international case law. And he pleaded for having the ICJ as kind of upper international court, which would guarantee the unity of jurisprudence, and which means interpretation of international law. In that respect, I think that his statement was extremely useful and important. Perhaps it contributed to the fact that we can say 20 years later that although a number of new courts were constituted, without even speaking of the multitude of international arbitration tribunals, in particular in the field of the settlement of disputes between private investors, foreign investors, and states. Although there was such a multiplication of judges and international tribunals, there was not a real fragmentation, just the contrary. I would say that a reference to the jurisprudence of the ICJ is more and more important. And I'm involved in a case which, of course, I cannot indicate because it is still under consideration, where I already know that the final decision of the tribunal will refer back to the position of the ICJ in a certain field. So yes, indeed, the ICJ does remain, for a series of reasons, because it is the principal legal judicial organ of the UN, the body which can play a significant role. As you have seen, my judgment as to its jurisprudence is very nuanced. I would have liked, as for me, that much earlier in time, the court qualifies certain obligations as peremptory. I would have liked that, although the law is still not quite well codified in that field, the court distinguish between the different legal regimes of responsibility. I would, of course, even more have liked, as counsel to Italy, that the court does not establish, as it unfortunately did, and I think it is a technical mistake, kind of a barrier between primary rules and procedural ones and secondary rules. I think this is a nonsense, if I may say so, because per essence, the definition of secondary rules is to be at the service of the respect of primary rules. You cannot simply say the principle of immunity of states belongs to procedural rules. This is one thing, and this is distinct from primary rules which are at stake with the respect of humanitarian obligations. But that being said, as I ended up my lecture, I still have very much respect and hope in the court, which is, by definition, the judicial body which can contribute to the maintenance of unity. You asked me about the composition of the court. I mean, it's difficult to speak of that, not only because I know most of the judges, but because one way or the other, due to the permanent change in composition of the court, a renewal of its composition, and the fact that so far the court or the countries, that General Assembly and Security Council, have succeeded in maintaining the representability of the international legal culture within the composition of the court. It would make no sense to say that one court in its composition of that date is better than the other. There is kind always of a balancing. Of course, at the very beginning of it, you had big stars within the court, just like Hirschlauter part or Alejandro Alvarez for the Latin American countries. And they played a very important role, or Jules Badevant. But you have also excellent judges within the court, not of all of them being of the same technical quality. I think what is important is that every judge, as much as possible, remains independent from its own state, from its national state. That is a big condition, and that is, in principle, respected.
Thank you. I will now pass to the questions of the students. I have 5 or 6 questions here, and do you want me to just go one by one, I think? And okay. Fernando Porto Sá asked that, Professor, in the title of this lecture, you refer to the international order. Why do you conceive it as an order rather than, for example, a system?
Okay, that's a very good question, and I deal with it in the text, the written text of the article out of which I made this presentation. It's a good question because I don't think that the two of them are exactly equivalent, and it is all the more important that it's a question of culture and it's a question of language. In English, you don't find very often the term international legal order, but you find it. And for instance, Hirschlauter spoke always of international legal order. Whereas in other languages, you find the term order. For instance, in Italian, and by the way, Italy is one of the legal cultures which by far most contributed to the development of doctrine in international law. Santi Romano, to whom I referred, wrote a book, the title of which is L'ordinamento giuridico, not il sistema internazionale, no? L'ordinamento giuridico, which means that there is encapsulated in the concept of order a certain kind of hierarchy. A system may remain horizontal. An order means what it means, which means that in some respect, even before the explicit formulation of Article 53 of the Vienna Convention, you had a certain standing organization of the relation between rules and subjects of law, and violations as to the consequences of violation of obligations of the subjects with regard to their obligation. So legal order goes further than international system. I say that very often to my English-speaking friends. I say that because you referred to him and he's a good friend of mine. I say that to James Crawford. I told him, James, I'm sorry, but you should speak of international order more often. And he said, Pierre, you're right, and I'll do it as much as possible, but you cannot change the language that easily and the traditions. But he agreed with me that the two are not equivalent and that we are confronted with an order as far as international is concerned.
Interesting. Rodrigo Franco asks you, Professor, how can one assure a material completeness of a legal order rely on principles, as Lauterpacht advocated for, without compromising its purely legal character? Is it possible to identify such principles without resort to subjectivity? Is the International Law Commission draft on principles succeeding in that direction, in your opinion?
Well, that's once again a very good question. And one of the criticism exercised against Jus Cogens from the start was to say, well, you speak of peremptory norms that you don't know, you are not able to say what it is. You cannot say what are the rules which are not, which are peremptory. And Jan Brownlee even said once, well, it's a nice vehicle, but it remains in the garage. I'm sorry, but once again, I had several opportunities to do that. I do not agree with what my good friend Jan Brownlee said. One may perfectly identify normative peremptory norms. The problem, and this was why I am thankful to this, to having the person who asked this question. The problem is that you find there, again, kind of a tension, because some of them, the majority of them, are simply crucial human rights, all the rights which directly belong to the respect of dignity of the human being, which means already quite a lot. And we saw, for instance, that torture would be one, as, by the way, the very, very active Inter-American Court of Human Rights has begun to say it for decades now. And I must say I'm very, very respectful and admirative for the work delivered by the Inter-American Court. So you can easily draw the list. And by the way, if you want a formal criterion for individualizing those human rights principles which are non-derogable, please go to Article 14 on the Covenant on Civil Rights. And you will see that there is an indication of those rights which are not able to accept derogation. That's a formal criterion for identifying material law. Now, the problem is that there are other principles, the beneficiaries of which are not the human being, but the states themselves. And I did not say that the immunity of jurisdiction principle is such a principle, but I said that the principle of equality of states so far is a constitutional principle, and I could elaborate upon it. You can modify the constitution. You could also modify a peremptory rule. But anyway, it's distinct. Whatever the case may be, the problem is that there is a potential of clashes between some principles and others. And this is indeed not necessarily a weakness, but a difficulty in the stabilization of the corpus juris of peremptory norms. And there, the ICJ, to go back to your question, could, of course, and will perhaps, I hope, play an important role. It's a question of time. And we can hope that the degradation of the human environment will leave us enough time for watching the court expanding its case law.
Okay, I have here another 3 questions, and we do not have more than 6-7 minutes. So I will put to you the 3 questions, and you decide what you think it's best to answer. Ana Lúcia Badia said, Professor Dupuy, good afternoon. In this complexity of international law, how do you think international law can make a concrete contribution to a sustainable development? And continuing, especially in relation to transnational companies. Moisés Montiel, Professor, you have mentioned that the peremptory norms are essentially customary law. Would you mind elaborating on this idea, seeing as the theory of imperative law is still very underdeveloped? And finally, Igor Jolanda, Professor, considering the Article 66 of the Vienna Convention on the Law of Treaties, do you believe that already exists a compulsory jurisdiction of the ICJ when the object of the dispute is the interpretation or application of an international use coherent norm? In this case, it would be restricted to those who are signatories to the convention. So these are the 3 final questions. If you need me to repeat anything, and
could you please repeat a little bit the first of the 3 questions? I'm not sure that I got it exactly.
Yes, Ana Lúcia Badia asked that in the complexity of international law, how do you think international law can make a concrete contribution to a sustainable development, development? And she's concerned of this question in relation to transnational companies. We have another 5 minutes, so you decide what do you want to do with this.
Okay. Well, first question, I think very much that sustainable development needs to be developed in its content and implications, in particular because from the Rio Declaration of 1992 onwards, it was not definitely enough developed and defined. So we could hope that it will be developed basically by the states. And this is one of the reasons why the successive which means meetings or the Paris Agreement are very important, because they not only deal with climate change as such, but with the whole global environment. And that could be, of course, or one could even derive from any future real progress in that respect, what is to be understood under sustainable development, which I define very often more than as a conceptual matrix, as a true principle. But still, we have reached a concrete point where we can watch, and by the way, COVID-19 does belong to the environmental problematic, because you know why COVID-19 was provoked in particular by the restriction of the area of life of some wild animal species. So it's clearly connected. So we are in such a trouble now with this scale of danger and challenges that we still have to hope, and the international civil society has here a role to play, to put the governments under pressure so that they develop what is to be understood under sustainable development. You cannot expect from the court that it will say much more than what was already said by it in the Gabčíkovo-Nagy-Maroš case in 1997. Second question. Well, I don't agree at all with the person who said that customary international law is that far not very well developed. It is the object of interpretation. But customary international law is as old as the history of international legal orders. And as I said, there was already one during the time of the Kadesh Treaty. And a good and large part of international law does remain customary in essence, is being codified, and we must pay tribute to the fantastic work which has been so far done by the ILC. And as far as the belonging to peremptory norms to customary international law, after having said that the ILC has so well worked, I must say that I'm a bit anxious about the present state of the first reports on peremptory norms, because I don't want to be too critical, but it sounded that the special rapporteur was not absolutely sure whether by treating peremptory norms he also dealt with customary international law. I'm sorry to refer back to one of the semantic fundamental articles which was written in French by Professor Michel Virali in the Annuaire Français de Droit International back in the 60s. Qu'est-ce que le droit impératif? What is jus cogens? And you will find here the perfect definition of the fact that per essence, customary peremptory norms belong to customary law. Good question also, and last question on 66. I would say yes, so far an action before the court based on 66 would be so far restricted to states parties to the convention, or at least it would be much easier to having as a state its locus standi recognized if such a request emanates from a state member of the Vienna Convention. And by that, I think we have to stop.
I think we reached our time. It was a great pleasure to meet you, not in person as I would desire, but with this distance, at least it was possible for all of us to be together. And I thank you very much, and I hope you stay healthy in the southern of France and enjoy the very nice summer in France. And I thank all of you as well.
Thank you very much. Thank you very much, and I reciprocate my wishes.
Okay.
Thank you. It was a great pleasure.
A great pleasure. I will leave now. Bye.
Okay. Thank you. Bye.